All right, everybody, cameras on and stay on mute. Cameras on, everyone. Please stay on mute. Cameras on and everyone stay on mute. If your name is not yours, if your screen name is not your name, you need to change it. There's nobody in here that's named iPhone and nobody named Rule Nice Eye. Change your screen name to your name. Your name is not Rule Nice Eye. Your name is not iPhone. Sir in the white t-shirt, change your name to your name, not Rule Nice Eye. Your name. That is not your name. Change your screen name to your name. Everybody change your screen name to your name. Turn on your cameras. Everybody, cameras on and stay on mute.
Everybody needs to listen to Sarge. Cameras on, stay on mute. Everybody, cameras on, stay on mute. Welcome to the kitchen where we are currently making dinner. Legit, almost ready. We are going to watch a divorce thing tonight. It is only 1 hour and 10 minutes long. It is not 8 hours, I promise you. It is, however, Judge Lockhart again. If you are new here, welcome. This is my kitchen. I didn't do my hair. Okay, let's keep going. I am glad to see you all here, and I am excited to watch this with you. I have not watched it yet, so let's watch it together. Okay?
First Divish. Today's date is April 25th, 2023. This is date and time set for plaintiff's motion regarding custody. Ma'am, you're top left to me if you just state your name for the record.
Alicia Divish.
Thank you. And sir?
Daniel Divish.
All right. So as I stated, we are here for plaintiff's motion regarding custody. The way this works, ma'am, is you have the burden of proof since it is your motion. So we'll start with you. I can allow you to start with a witness, start with yourself as a witness, or you could call Mr. Divish as a witness. We can do opening statements if you'd like, just so the parties know I have gone through the file. Sometimes people would like to make an opening statement, which is just a kind of an opening argument, or you kind of lay out how you see what the evidence is going to show. The one thing, when people are unrepresented, I try to make this clear, and it doesn't always work, but sometimes the opening statements just turn into testimony. So then if that's what it's going to be, I just swear you, it's not testimony. Your statements are not testimony until you're under oath. So just if that's helpful,
Okay.
you can give it an opening statement if you'd like, but just remember that if it starts becoming testimony, I'm going to swear you in and we'll just repeat everything we did. Okay. So that's the only other issue with regard to opening statements. Otherwise, you feel free to do that. We talked a little bit off the record. No one is in the waiting room now, but I think, ma'am, you mentioned you might text a witness whenever you want that person to appear. So I will leave that to your discretion.
Okay, so if I were to do my testimony and then have the witness come in and then Dan could have his testimony, would that be a good format?
Well, I'll let you choose how you want to present your case, but that's certainly a way you could do that.
Okay,
right.
that's
So you'll present your case, which could be, like I said, you testifying as a witness, whatever other witnesses you have, including Mr. Divish, if you call him. He'll be able to cross-examine or ask witnesses questions. And then if he chooses to, he'll be able to present his side of the case, so he could introduce witnesses or exhibits or testify himself.
Okay. So I would
let me know. Yeah, let me know if you have any other questions, but that's kind of a general format.
I read a lot about how this goes. I think I'm good. So I would like to give my testimony then. So if you want to swear me.
Great. Thank you. If you'd raise your right hand, please. Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So for the last several years, since Calissa was 6, I have been the sole caretaker for her physically and legally. I've done everything that is required of a parent to take care of her because Dan has not been available. Before that, I'm not going to say that Dan wasn't around. He took care of her a lot. He was there for her when she needed him. And that's not what the reason I'm seeking this for is. It's to put on paper what has already been the reality of things. I've been 95% responsible for food, clothing, other material needs, medical care. I have received less than $750 in support from Dan since the beginning of it being ordered in 2012. So all finances have been my responsibility. She's lived, Calissa, our daughter, has lived in a stable and satisfactory environment with me for 11 years. And in the last 7 years, she's been with me 100%, except for 14 days exactly being spent with Dan overnight, and it was with her sisters. Calissa and I both have the desire to maintain that continuity. He's been to prison twice, once for assault with a dangerous weapon and assault with intent to do great bodily harm, less than murder or by strangulation against his then girlfriend. And a second time for a parole violation for having cocaine and brandishing a gun in front of all four of his daughters, myself, his brother, and his brother's wife and son. Dan has only gone to one school event in the entirety of Calissa's 8 years in school. He has never taken part in enrollment, homework, or gone to a conference or open house. There have been several instances of domestic violence in regard to Dan, some with Calissa present and some not. You'll hear from the witness that Dan was also in a relationship with his oldest daughter's friend, who was 16 at the time. I'm willing and able to facilitate and encourage a close and continuing parent and child relationship between Calissa and Dan with safeguards in place. He currently calls her twice a week, and I encourage it. I want Calissa to have a relationship with her father, but I don't think it's safe for her at 13 years old to be spending time alone with him for extended periods of time. There have been so many times where I've appreciated Dan's parenting. He has been there for us in his own unique ways, and I think that he's charismatic, street smart, and book smart, and he's like, he could be somebody that I called a friend. But there's also very, very bad decisions that he makes, and I fear for what Calissa will be put through now that she's becoming older. And she worries about the same thing. And I hope that everything that I've taught her so far will help her navigate anything that she experiences, but I need to do what I can to make sure that she's good. That's all.
And so for the record, we spoke a little bit about a mediation agreement the two of you entered into. It became an order with the court on January 17th, 2023. Without talking about what you all discussed at mediation, if you could tell me, so what I'm getting at is usually at the end of someone's testimony, I'll say, well, what, in general terms, what is it that you want and why? And you've given me some reasons. So if you want to add anything else to that, and also any discussions with regard to that, the court's order that was in place in January.
The agreement that we came to was, first, this is Calissa's request. She wants to talk to her dad with a counselor for the first time or two because she has things that she wants to express to him, and she wants to do it in front of someone, but I wouldn't be an appropriate person. She wants it to be somebody who doesn't know her that well and can just sit there and support her. After that, she wanted to do short during the day visits where they go shopping, thrift shopping, to the restaurant.
Well, I can't. So just to assure you, I'm going to meet with the child today at 4.
Yeah.
I'll be able to talk with her about what she wants. This is
Well, that's what we all agreed to. Like, that's what the agreement was. So
I
was telling
understand.
you-
I understand that's what you all agreed to, but I'm asking you, is that something you no longer want?
That is correct. I no longer want that. However,
And
After
why?
super-
Then that's what I'm getting at. Okay.
after supervised visits, that would be ideal. That would be an ideal setup for her to be able to see her dad.
In other words, if I can understand better, your request is you'd go through those steps as outlined with the end goal of supervised parenting time.
No, supervised parenting time to begin with. And then that would be the option after supervised parenting or whatever. I'm sorry, supervision, whatever. I'm asking to add the supervision before that if possible.
Because some of the agreement at this time, it doesn't start with supervised visits, does it? Or it doesn't, okay. Okay, anything else you'd like to add or say, ma'am?
I feel like that was the best way that I could express the things that I think are pertinent to this. I could text her now if you'd like.
Your witness?
Yeah.
Sure. Mr. Divish is going to ask you, so if he has any questions, he'll have the opportunity to ask you those right now. But you're welcome
Okay.
to text your witness. Sir, do you have any questions for Ms. Divish?
Is it possible for me just to wait till this is all done and ask, or is it stuff I have to talk with her right now about? I guess I'm quite curious to know exactly what's going to be said about me before I start asking questions about it.
Well, so if we picture a courtroom, I know that you don't have attorneys, but if you picture a courtroom, this would be like Ms. Divish sitting at the witness stand and someone
I got
asking
you.
her questions. So she's on the
Okay.
stand now. What you could do, sir, I guess, is maybe this is what you're asking is when you present your case, you could call her as a witness. Is that what you're asking me? In other words, if you don't have any questions right now, you don't have to ask her. And then once she's done presenting evidence and you would like to present evidence, you could call her as a witness and then ask her questions then. She would have the ability to respond and then expound upon that testimony. So, but I guess if that, I don't know if that answers your question.
Yeah, I guess can I be sworn in to kind of say what I have to say so we can?
No, because it's not your opportunity yet. So you haven't been called as a witness. Everyone's listening, right? I mean, you haven't been called as a witness. You're going to have your opportunity to present your case.
Gotcha.
So you aren't a witness
Okay.
right now. You can't be sworn in.
All right.
You can ask questions.
I guess I thought I had to be before I asked questions. I apologize.
No, you should.
So-
No, let me. No, I'm sorry if I'm not doing a good job explaining. But if you have any questions, now's your opportunity.
Okay. So, Alicia, you're saying a total of 14 days and 7 years is what she spent with me?
No,
Was I right? I heard the 14 days. What was the time period you were saying in that?
what year did you went to prison in 2018?
Yes.
5 years.
So you're telling me
But
that my
in
daughter
the-
has spent.
But in
Go ahead.
the 2 years before that, we weren't doing the 3 weekends a month and then half the summer or whatever. That didn't happen for almost 2 years before that.
You're right. We were doing every other week on, week off, the same as I did with my other kids for the last 10 years.
She was in school. She started school when she was 5. We didn't do every other week when she was in school.
So in 5 years, she spent 14 nights with me, is what you're telling me.
With you alone and with the other girls.
Okay, so with me, you're not telling the whole story of this, because you and me did have a relationship where my daughter was there with me at my house while I was out of prison every single weekend up until when we split. And then after
Time served. Thank you so much. Everybody, thank you so much for all of your generous gifts tonight. But thank you very, very much, Time served. You've been so supportive and so helpful over these last weeks. And I am excited for the future. Phil got a Manning letter. It is on my list of goals. Also to have a Times Square ad, but that's just a new one I've added today. I love you guys all so much. Okay, we've talked about this judge. He's a referee, first of all, not a judge. Second of all, originally I thought he was Judge Surfer because it was an 8+ hour case, and he was like dreaming of surfing. That's what I believed. But we watched a lot of that case, and out from the shadows came Judge Lockhart, who, like, as in Gilderoy Lockhart from Harry Potter, because he does have a Gilderoy Lockhart vibe. And some people really think he's like super duper sexy. He's not super sexy to me, but I do like how he controls his courtroom, I'll tell you that much. Sometimes he just like whips his tongue and he's like, bam, no, this is the way it's gonna be. Yeah, you guys are awesome. The dinner has gone out. That was burgers with salad, potato wedges, and my special mayo, which is mayo, but this kind of mayo. Because it's got half the calories, guys. It's a Japanese mayo. And then paprika and garlic salt. There you go. There's a recipe for the day. I love you guys so much. And let's continue as Matthew Hagen. And also, what is this room this guy's in? It's like a set for, I don't even know. It looks like a security outpost or something. I really don't know where he is. And she looks like she's in a counselor's office.
After that, it was maybe not every weekend, every other weekend. Yes, her sisters were there because I had custody of them. So maybe not necessarily alone with Calissa, but you're portraying this like I've only seen my daughter 14 days, as well as the other thing that it's important to say.
Here, I'll cut you off. So I don't see a question coming. You're only able to ask questions. You will be able to testify when it's your opportunity.
Yep, I'll let it be. That's good for now.
You don't have, so that wasn't a question?
I guess you're saying that I've only spent 14 days in the last 5 years with my daughter. That was the question I had, I guess.
I marked it all on the calendar, and I wasn't trying to mislead in any way. I specifically said with just you and your daughters without me there. So there were plenty of times with me there, yeah.
Okay. That's fine. That's enough, Your Honor.
Thank you. Ma'am, this would be what we'd call redirect. Any statements you'd like to make to clarify any of his questions or your answers to his questions?
No, sir.
Okay, thank you. Your next witness, please.
I'd like to call Danielle Davis, please.
All right, and that is the person in the waiting room. Good afternoon. Oops, you're on mute there. It's on mute now. I think we are clicking. I'll let you. There we go.
Now, can you hear me?
Yes.
Okay.
Good afternoon. Ma'am, you've been called as a witness in this matter by Ms. Divish. She's going to have some questions for you. And then if he chooses to, Mr. Divish may have some questions for you. Okay.
Okay.
All right. If you raise your right hand, please. Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Divish?
Hi, Danielle. How are you?
Good, thank you.
Good. It's nice to meet you.
Nice to meet you.
Could you please tell me where you work?
I work for Michigan Department of Corrections in Otsego County.
And how long have you been employed as an agent in Otsego County?
I have been a probation parole agent there since 2010, 2011.
And how do you know Daniel?
Mr. Divish was on parole with me in Otsego County.
And when he was on parole with you, can you tell me how he did on supervision?
Yes, initially he was doing well. He got out of prison, was referred to counseling with Jeanette Sayer. He was attending counseling, working, got employment, was drug and alcohol free. And from everything that I knew, he was doing fine while on supervision.
So what exactly happened to have him violate his parole, or what were the circumstances surrounding that?
So Mr. Divish, while on parole, had made some decisions throughout the term that were not brought to light until later in his supervision. So where I thought he had been doing well in his supervision, it had then come out. There was an incident in 2019 that he was in possession of a gun. You were present. His 4 daughters were present in the home when he was waving the firearm around. And then in 2019, his oldest daughter, Gabby, had moved in with him because of some circumstances that she was going through. And then while she was living with them, he had become involved in a relationship with her best friend, who at that time was 15 years old.
So you said in November 2019 that he was in possession of a firearm.
Yes.
Was that one of the only reason that one of the reasons that his parole was revoked, or was there another thing that had happened?
Yeah, when he ultimately got returned, MDOC, which I printed off his preliminary parole violation hearing, which there was probable cause found on, and I guess stop me if you don't want to know all of the charges, but there was probable cause found for violating condition 4, that on or about October 2018, he was involved with behavior that was in violation of state law when he engaged in a sexual activity with a victim, a minor, Rebecca Owen. Count 2 of his violation that they did find probable cause was on or about October 2018. He was involved in behavior which constitutes a violation of state law when he used a razor blade to carve in the skin of the victim, minor Rebecca Owens, for sexual gratification. Count 3, there was probable cause, violation of condition 4, on or about the dates of March 2020 to December 2020. He was involved in behavior which constitutes a violation of state law when he forced sexual acts on a Miss Mindy Coates without her consent. Count 4, violation, the same dates, March 2020 to December 2020. He was in violation of state law when he physically assaulted Mindy Coates for sexual gratification.
Lock him up. Keep him
The
locked
next
up.
one, count 5, violation of condition 4, probable cause was found on or about March 2020 to December 2020. He engaged in behavior that was assaultive, abusive, threatening, or intimidating by physically assaulting Miss Mindy Coates for sexual gratification. Count 6, there was probable cause found that on or about the dates March 2020 to December 2020, he engaged in behavior that was assaultive, abusive, threatening, and or intimidating by telling Mindy Coates that he could make her disappear if she came forward. Count 7, there was probable cause found that on or about November 2019, that he was in possession of a firearm, an imitation firearm, or simulation of a firearm. Count 8, there was probable cause found that on or about August 2019 to December 2019, he was involved in behavior which constitutes a violation of state law when he physically assaulted Alicia Divish for sexual gratification. And then count 9, there was probable cause found that on or about, he violated count 9, condition 4, that on or about August 2019, December 2019, he engaged in behavior that was assault, abusive, threatening, and or intimidating by assaulting Alicia Divish for sexual gratification. So these were, he asked for a preliminary parole violation hearing. There was probable cause found on those counts. And then Mr. Divish was ultimately returned to prison for the parole violations.
What was his original reason for going to prison?
His original charge, if you give me 1 second here. The original charges that Mr. Divish went to prison for was 1 count of assault with intent, great bodily harm less than murder or by strangulation, 1 count of domestic violence, aggravated second, 1 count of assault with a dangerous weapon, felonious assault, and then he did have a count for a misdemeanor domestic violence that was adjudicated through just jail only. But the other 3 is what he was sentenced to prison for.
And who was the plaintiff in that?
In that case, the victim in this case was a Miss Sarah Bean.
Okay. Do you have any concerns about Mr. Divish and his parenting of my daughter, Calissa Divish?
I do. Although, Mr. Divish was not charged criminally, there was probable cause after I was contacted by a minor victim's father. This minor victim was the defendant's oldest daughter, Gabby's best friend. At the time, they were 15 years old. Mr. Divish, in which I can read specifically from the probable cause that was testified and talked about right at the time of his hearing. His oldest daughter, Gabby, who was, I believe, 16 at the time that she testified. I could be mistaken. She may have turned 17, but I believe she was 16. She testified that in October of 2020, she had observed her father waxing the minor victim's vaginal area and had asked her if she wanted to help. She stated that her best friend, Miss Owens, told her that she had been having a sexual relationship with Mr. Divish, who was Gabby Divish's father, and that Gabby Divish and Rebecca Owens, when they spoke of it, the victim stated that it began at 15 years old. Parolee Divish admitted that he had permitted the minor victim to walk around the house naked as he was a nudist and did not see anything wrong with it. And he did admit to waxing the victim's vaginal area, stating that, this was not against the law. And he did state, though, that he waited to have sexual intercourse until Miss Owens was 16 years old. That he was in love with her, and that when she turned 18, he planned to marry her.
Do you know how old Calissa is?
Well, gosh, at that time, Calissa, my guess at this time when this was happening, she had to have been maybe 3rd or 4th grade. So I'm saying now she's got to be about 13, 14. So
She's
right
13.
around, I'm sorry?
She's 13.
Okay, so just a couple years younger than when this activity started with this victim. So that is my concern. And state police was investigating this offense. However, the victim did not want to testify in the court hearing because, or with police at all, because she loved Mr. Divish and wanted to be with him. So she was not going to testify to any relationship. Therefore, state police did not have a case without her testifying.
Thank you.
You're welcome.
That's all I have.
So, when was his parole revoked, ma'am?
His parole, let me tell you when he was returned. Give me 1 second. I'll be going back and forth between screens here.
Because I mean, just for the record's sake, he's currently appearing from prison. Did you know
Correct.
that?
Correct. Yep. He was returned to prison. It was in, and he can correct me if I'm wrong. And it's looking like it was April 2021 that he was returned to prison.
Do you know how long, what his earliest out date is?
This was showing, I know he had a hearing in front of the parole board in which he could probably tell more. But at this time, yeah, it's not updated. It's just showing. Yeah, it's not updated in my computer here because right now it's showing the SGT max date as 3/9/28, and that's all that I'm seeing. I'm not saying the PMI date that it's showing was 2/9/2020, but it's not, there's nothing more updated in here. So he could probably advise the court more on that end if he has something coming up with the parole board.
Well, I don't know if he's going to testify today, so I'm asking you, do you currently work for MDOC?
I'm probation parole. I am not in the prison, so I don't calculate their out dates.
And you don't have access to that either?
I'm on the screen, but it's showing a PMI date as 2/9/2020, and his max date is 3/9/2028. And that's all that it's showing me right now.
Okay, thank you. Mr. Divish, do you have any questions for this witness?
Yes, Your Honor, I do. All right, first, you made a comment, you're worried about me and Calista.
Oh. Just before he gets talking, because I am not gonna like it. Hi everybody, welcome to the room. It's not our normal content, but this is an unfortunate case and it's a lesson to be learned about talking to your family and your children and making sure they are comfortable talking to you about things. She, just to break a little bit of the tension here and make it a little bit funny, does the lady from MDOC not look like she's in a van? Like she's in the front of a van and then the back, she's sort of just in this like van. And then his room, if it was a electric chamber, that would be more helpful after his whatever. I can't even, I mean, they're just, it's ridiculous. I don't even understand what the question is here. What does she want? Give it to her. What does he want? No. The answer is no, you can't. That's basically it.
Because of her age. Can you elaborate exactly what you mean by that?
I did. I said that she is only a couple years younger than when your relationship, she's 13. Miss Owens' relationship began when Miss Owens was 15. So my concerns are not only with your children, but also any children that your daughters bring in the home.
So you're saying there's a concern, you think that I may do something inappropriate to my daughter. I just want to make sure that I'm clear on that's what's being, no one is actually saying it, but that is what's being insinuated right now.
Correct.
Gotcha. So with this this girl that I was alleged to have a relationship with. You said that I had a relationship with her. When did I say this?
While you were incarcerated in the Otsego County Jail.
Okay. Was there ever any documentation of that? Like, was there, because I
Yes,
don't recall ever saying this.
Would you like, okay, so I'll go into case notes if you would like.
I mean, case notes are one thing. Is there any kind of recorded document of this?
I don't know if you admitted to it during the preliminary hearing.
Okay.
However, you know, case notes are important because, you know, we document everything in our case notes.
Okay. Okay.
And I am under oath where I would tell the truth. Therefore, you know, I'm testifying that we were in the Otsego County Jail when you admitted to having a sexual relationship with this woman, this child then.
Okay. I'd also like on that note, Your Honor, I'd like to clarify that they keep referring to this girl as a victim and refusing to testify. She was not a victim of any kind, and actually she was interviewed by 3 separate places, and all 3 times.
My dude. Oh my God. Does he think it sounds good? Does he think that sounds good? She's no longer his PO because he's no longer on parole. He's no longer on parole. He's in jail. And his max time date is 2028. And I really hope they can find some other charges. This is ridiculous. That's not what. Oh, Judge. Oh, please. Please. It doesn't even matter. It doesn't matter if he groomed the child to give him consent and then and then he managed to get her at a weak moment or whatever. She's a child. She does not have that capacity. So I'm sorry, sir, but this is not cool, my dude. Not cool at all. These 2 women up here are brave, though. They are both standing there looking him down, staring him down straight up. And me too, I'm here mad. I hope Mr. Hagen is here with us, about to do the same thing. I don't know what's being asked, but I'm not happy about why he's even allowed to be asking questions like this. Like, again, this is re-victimization. Thank God the victim's not there. And don't you dare get her name out of your mouth. Get her thought out of your head, is my feeling on it.
Was proven that nothing happened. But so what I'm getting at though is, so you're saying that I told you that I admitted to doing this. So obviously my words were good then, and you believed that I did this, correct?
You told me you waited until, I believe her birthday was the end of February, and you waited till after she turned 16.
Okay. So again, what I'm asking is you're saying that I'm a pretty truthful person and you believed what you said that I said?
I had no reason to doubt what you had said.
Okay. So my next question is I'm having a hard time understanding, isn't you testifying right now an extreme conflict of interest?
How is that?
Seeing how that there is a current investigation between mine and yours personal relationship.
There is no investigation. It's been closed.
Why was it closed?
I have the paper here. On March 1st, 2023, this letter is to inform you that this complaint against you was investigated and is now considered closed. The investigation produced insufficient evidence to support the allegations, which were made by you, Mr. Divish. Thank you for your patience during this investigation. Based upon this finding, this matter will not appear in your personnel file.
Okay. So the next question I'd like to ask is, Obviously, you know what violations I'm in prison for. What violations specifically am I in prison for? Not all the violations that were
the gun,
alleged. What
the
am I?
gun, the gun where your children and Miss Divish were present.
Okay.
Is the one
So,
you pled to?
so what you're saying is our investigation between you and me was dropped because there was no evidence, there was nothing that happened according to you.
Right?
But yet all my violations were dismissed, but yet somehow they keep getting brought up and used against me when they were absolutely false.
Were you
So
sworn?
I guess I'm finding it.
Were you sworn
Well,
under
I'm-
oath? Were you sworn under oath today to tell the truth? In this
No,
courtroom?
so ma'am, I don't know if you've appeared in court before, but this is not.
I have.
Then you know you're not supposed to be asking questions. You answer the questions asked.
Then can I ask you, sir, if he's been sworn in under oath today?
You can answer the question as asked. That's what you can do as the witness.
No, no, I'm asking you, has he been?
I know,
sworn
I heard
under
you.
oath?
I'm telling you what you're able to do right now.
Okay,
So again, what I'm saying is that it seems like a big conflict that in one moment something can be dismissed and it's fine because it's beneficial on one end, and then on another end it can be dismissed, but because it's not beneficial on that end and it hinders me, then it can be used. I mean, I keep getting put on trial for the same thing over and over and over again, and this seems like, considering the allegations between me and you, there's definitely some
and I'm gonna stop
what's-
you because there's no allegations between you and I. Let's just make that crystal clear. There's no allegation. So there's nothing
It's-
to even investigate further. So
Well,
there is
there-
nothing.
there
She
was.
asked me to,
Hold on.
what you got returned on was the gun charge. And she asked me if I had concerns.
Okay. And
So, and I answered the
record,
questions.
for the record, you wrote my PSI in two separate places. There were allegations between me and you. I'm going to move on from that.
No,
Either
that
way.
was reported by you to.
Okay. This has taken a very odd turn. She does protest a little much. I understand why. But she's giving his words a little more value than I think they should have. I don't know that anything happened to them, but she seems bothered by the accusation. He is making himself the victim, Gracie, and it's gross. It's absolutely gross. She does not like him. Why would she? Oh, y'all done there? Okay. Anyways, let's continue.
To the victim's father to
Okay.
deter him from calling me.
What I'm getting at, Your Honor, is
Now, again, sir, this is your opportunity to ask.
Yep.
questions. So you don't have to tell me anything yet unless you decide to testify.
Give me just 1 second. Your Honor, let me just. No, I think that's.
That's a great point. I wish the mom did know what she
I
was
guess
doing,
that's
but
that's
object.
pretty much about it. It doesn't. Yeah.
Okay.
That'll
So
do
I
it.
have
I
some
appreciate it.
follow-up questions too, because I guess I was a little confused.
Sure.
Ma'am, you read through 9 counts against Mr. Divish, correct? For
Correct.
his parole revocation hearing or what you're calling it?
That's what he got returned for.
Okay, and then when you're saying that there was probable cause found on those counts, does that mean he was found guilty of those?
So when he took it to a hearing, there's probable cause. A supervisor does the hearing, and there was probable cause to believe that he had violated these conditions of his parole. So he did get returned. Then once at the prison, then they sat on it and waited for anything else that he had going on in court and to make sure everything was clear. And then they offered him to plead to the gun charge, which was one of them that I had read off. He had pled guilty to the gun charge, and then they dismissed all of the other violations.
Okay, thank you.
You're welcome.
Ms. Divish, did you have any follow-up questions, any redirect for this witness?
I didn't. Oh, I'm sorry.
It probably sounded like I said Davis. I said
It
Divish.
did. I'm sorry. I'm like, yeah, I didn't have any questions.
No, sorry, Ms. Divish. Okay, Ms. Davis, thank you very much.
Thank you.
Ms. Divish, do you have any further witnesses?
I don't.
Okay, so Mr. Divish, at this time, would you like to present any evidence?
Yeah, I guess I just like to talk. I don't have any witnesses or anything.
Yeah, well, you would be considered a witness if you testify.
Then yes, I'd like to do that then.
Do you raise your right hand, please? Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, so obviously I'm probably gonna jump around a little bit, but you've heard a little bit, well, a lot from every angle here. So a couple of things I'd kind of addressed when I had talked to Alicia a minute ago was the amount of time that I had spent with my daughter. The way that it's being worded is very unclear, and just because she says 14 days alone with my daughter, that may have been, but I'd like to point out, Your Honor, is I have a total of 5 children. So it's very rare that I would just have one child at a time. So she says that, alone. Yeah, and that may have been the case. Most of the time, Alicia was there, or her sisters were there. So there definitely was a lot more time. And it sounds really bad when you say 14 days alone, when there really was hundreds of days over the 5 years we were together. I mean, hundreds and hundreds of them. But those specific days, I don't even feel like that's a fair number, but I just wanted to point that out. Having 5 children, it's hard to just have a one-on-one with a kid. So there's that. As far as the custody, I have never once, even though me and Alicia do not see eye to eye on a personal level at all, I have never once took away from the fact that she is really good to my daughter and that she has done really good for my daughter. Up until recently, we've actually done relatively well with each other as far as co-parenting. We don't really slander the other person in front of our daughter. We try not to hold our differences between us with our daughter. And I do appreciate that, Alicia. Like we have managed to do that for a number of years. So I'm not discrediting that at all. So there's that. One thing I did want to point out too is while I was out of prison, like I said, I kind of touched on the custody. The last 6 months I was gone, Alicia left the state. I did not want her to leave the state. She left the state and she took my daughter. She traveled around the country to different places, seeing cool stuff, which I don't doubt wasn't an amazing trip by any means. And I know my daughter loved it. But still, that's why I didn't see her for the last 6 months she was here. And that was not something I wanted. And as a matter of fact, when I said I wanted her return, that's when she went to my parole officer and, assault and rape allegations came out. So honestly, Your Honor, I'm really quite nervous on how this is going to end, because if it doesn't end the way that she wants, I don't know what's going to happen to me. I mean, in the letter that she wrote to the court for her, I guess I'm not sure the appropriate term. What she wrote to request this hearing?
The motion.
The motion. There you go. Sorry, I couldn't think of that. In the motion, it even said in there, I was hoping he'd be here till she was 18. I mean, this just shows you like some of the level of vindictiveness towards me. Again, we are good to our daughter, but we are not good personally towards each other, and that's very well known. So I mean, I apologize. I'm getting kind of flustered with this. And then there's all these allegations that get thrown in there about different things. Like Danielle had said a minute ago, I got so like she explained it, I get these allegations. I did a probable cause, and they're basically like, yeah, we could see that. So they sent me back to prison. Then I had a hearing, a court hearing. I went through and they went, yeah, you didn't do this, you didn't do this, you didn't do this. But yet somehow, every time there is something legal that comes up, these things keep getting held against me. It's the equivalent of holding OJ guilty for murder, even though he was found not guilty. That's what keeps happening to me. And there are suggestions out there that I would do something to my daughter. Are you kidding me? I don't even want to say on this camera what would happen if somebody did something to my daughter. As a matter of fact, the guy who did something to my other daughter is in prison, from what I understand. I mean, I just, that's insane, of all the years that we've known each other. That
What? Like, so if somebody did what you did, you would get really mad about that? Okay, wow. This is just full of ridiculousness. I'm making the beans, this is called the onions. Softening the onions, putting the garlic in. Let's continue. I don't like this guy at all. I don't like him at all.
she could even think that I would do something to my own kid. I don't know. And a lot of the stuff with my parole officer, like I said, you heard a little bit. There was an investigation between mine and her relationship, and it seemed very that as soon as that investigation was closed, within a couple days, she was introduced as a witness to my child custody case. I mean, this just, I mean, it just doesn't seem appropriate at all on that aspect. I haven't been the best dad. I understand this. I'm in prison. There's only so much I can do to be in my kid's life from prison. I have been trying to get away to visit my daughter since I've been here, and it has not been successful, but I do maintain regular contact with her, which obviously Alicia had already told you. While I was in the world, even though I may not have seen her every day, I talked to her on the phone, texted her, or FaceTimed her every single day. Every day when I woke up in the morning, I messaged her good morning and that I loved her. And at night I did. Like, this was clockwork. And I know Alicia will vouch on that. So even though I may not have been physically right there the whole time, I have been beyond involved in my daughter's life. The time frame and the years she's saying are not appropriate. I did go to prison for just under 2 years, and then I have been here for 2 years. So those 4 years, I absolutely was gone. But up until that point, matter of fact, the day I got arrested, I had the kids, which I know doesn't sound very good, but I had my kids up until the day that I got in trouble. As far as supervised stuff, man, I apologize. I didn't mean to say, man. Even if I were to agree to it, any person that I may say I could be there with me, Alicia will find a reason to say that that's not an appropriate person. Obviously, I mean, it doesn't, I mean, you can look in and see, obviously we had something all set in stone, and then last minute she wanted to pull it back. I mean, what's going to happen if we change something now? Am I going to get out and she just decides I can't see my daughter and I can't do anything because she has full legal custody, and I basically just can't see my daughter for months and months until I go through the motions because I had my ex do that with my son, and it took me years to be able to see him because she did that. We've had joint legal and joint physical custody since we split. I don't know when exactly. I'm going to guess around 14 or 15. I don't know what year it was put in order. As far as the dollar amount, I can't prove or disprove anything. They definitely, I had to pay child support, but either way, we were still co-doing things on our own. As well as I haven't been to a lot of her recitals or anything like that. I have went to a daddy-daughter dance. I've been to a couple things. I also feel like it's important to know that once we split, she moved to Traverse City and I lived in Gaylord. So working all day and then trying to get over to things in Traverse City after work proved to be a little bit more difficult. Obviously, you know the distance between those two, so it was a little hard to do. Again, the supervised thing, just the way that things are being insinuated that I'm going to do something towards my daughter, I have no problem going to a therapist or psychologist or whatever you want to call it and talking with my daughter. I have no issue with that. I agreed to that right from the beginning. I've been gone for a while. She has went from a little girl turning into a young lady. I understand that things are different, and I'm certain she has questions about why I'm here. And I didn't even want to do just the 3 and 5 hour visits. I wanted to be able to take my daughter and do whatever we wanted to do. But I then agreed to that because that's something Alicia was pretty adamant on. But now it's like every time I agree, it's pushed more and pushed more and pushed more. I'm telling you, if we don't keep our custody as a 50, like a joint legal, joint physical, if it doesn't stay that way, all it's going to take is for her to get mad at me and I'm done. I don't see my daughter. And I know that I'm sure being in family custody hearings, you understand my concern with that. So I don't see the need for supervised visits. I mean, every time I talk to my daughter, we talk about things that we're going to do. I mean, I'm sure she's probably nervous to see me. It's been a couple years, and I'm sure she has some things she's probably wants to talk to me about that's going to make her nervous. But to even insinuate my daughter is scared of me is a bold-faced lie. So, or that I would ever harm any of my children is just ridiculous to me. So, I mean, I think that's about what I have to say. I mean, I know I'm kind of like a broken record and repeated myself. I'm obviously not a lawyer, not very good at this, but I mean, I don't know. I guess that's about it, Your Honor.
Did you have a parole hearing recently?
I did, yeah, back in March or October. I'm sorry. I haven't got the results yet. They don't just like tell you what you get right there. You kind of wait it out and you're at the mercy of that time. Because I am a parole violator, they could come pick me up tomorrow and tell me I'm going home. They could tell me I got to sit here for however much longer. It's not like a regular prison sentence where, you go on this date and you're getting out on this date if you get your parole. A parole violations is a completely different entity. So like I said, they could, as a matter of fact, they just took 12 people out of my unit today and released them. So it's really hard telling with that. But as of right now, no, I don't have an answer for you. I wish I had better words for you, but I don't know. And obviously, like the Omni system doesn't have that listed either. So,
okay, Ms. Divish, do you have any questions for Mr. Divish?
Yeah, we do actually. Before we went on the RV trip, how long had it been since you saw her?
You're really muffled, like there's something over your speaker or something.
Nope, it's up on a stand.
There you go. I can hear you now. What was that?
Before we left on our RV trip in November, when was the last time you saw her?
Last time I saw her was the end of October because I took her and her sisters out for Halloween. We went trick-or-treating and then got pizza like we did every other Halloween for as long as I can remember.
That was that was 7 days out of the 14 days that I was referencing that she had spent with you alone with your other daughters. I never said with you alone specifically. It said with you alone with your daughters. Do you remember the other time that she spent an extended period of time with you in the last 5 years?
I mean, when I was out there, obviously, the COVID thing was a little bit wonky. I know at the very beginning we were both kind of concerned about that. And I know I didn't see her for a period of time. But that was on both of us. I 100% admit that because we didn't know what was happening with the whole COVID thing. I don't write down days. I don't know. I cannot tell you an exact date. I can't tell you how many days in a row that I spent with my daughter, what day of the week, what we did. I don't know that, but I know that it may have not been 7 days in a row. Normally when we seen each other, it was 2 or 3 days was the normal. It wasn't normally 7, except, I mean, way back when we were doing week on, week off when she was littler or on the summer. But it was normally a few days at a time. So, I mean, I guess I'm beating around, but to answer your question, no, I can't tell you because no, I didn't remember. I just specifically remember Halloween because it was an important thing that we had done for many years.
The second time was in July for 5 days. You and Jason came to pick her up on the motorcycle. She stayed for
These are just questions, okay?
I'm sorry, I was just reminding him.
Okay, I do remember that, yeah.
Were there any other times while you were out that you spent more than a day with her without me there?
I'm sure I did, but I didn't feel it a point to write down every day that I spent with my children and what we did and how long. I guess I didn't think that would ever become an issue to the fact that I needed to keep record of it. So no, I don't know. I don't. I wish I could tell you more, but I don't know.
Was there ever a time Calissa asked you if she could come back with me early from her visit with you?
Again, I don't know. I feel like there was one time where she was kind of missing you and wanted to go. I can't be 100%, but I feel like there was one time that she just kind of got sad and wanted to see you. I'm about 99% sure that happened once, but that's the only time I can remember anything. But I'm pretty sure that one time that was the case. Yes.
Have you spoken to Gabriella since she testified against you about having a relationship with her friend Rebecca?
No, I haven't.
Why?
Because she hasn't reached out to me and I have no way to reach out to her.
What about your other daughters? When was the last time you spoke with them?
I mean, really, my other daughters is kind of irrelevant to this. We're talking about Calissa.
I believe your relationship with all your children is relevant.
What's that?
All of the relationships with your children would be relevant.
My children are obviously upset with me for coming back to prison, and every one of them copes differently. And I'm not saying that they don't have a right to be upset, but just because I haven't talked to Gabby doesn't mean that when I get out, it's not going to be rectified. Me and Calissa have tried to work through a little bit of our stuff and we're doing it now, but not everybody is the same. So, plus it's also important to state the fact that my daughter is a grown adult who's about to have a baby of her own. So it's not like she's a little kid here. Like she can make her own decisions the same as I can. And it happens. There are times where I didn't talk to my parents. There are times you didn't talk to your parents. Like this happens. So, I mean, I understand what you're trying to get at here, but on the flip side, that's kind of irrelevant to what we're talking about.
It's not. It has to do with your relationship with your children. Where do your other children live?
Like, You mean physically live?
Where
or
have
what
they
town?
lived for the last, where do they, who are their parental guardians? And how long have they been their parental guardians?
Well, Gabby is obviously almost 19 years old, so she's her own guardian. Hannah, as of right now, I have 50-50 custody with Hannah. And she, I believe, stays with her grandma because she prefers that over her mom. And then with Piper, she stays with her mom. And then, of course, Nico, my son, he stays with his mom.
You said you have 50-50 custody of just Hannah or all of the kids?
Of Hannah and Nico. I don't of Piper because when the custody hearing was happening with Gabby, the only way that we could get Gabby removed from the situation she was in to give me custody is if I gave full custody of Piper to Rochelle. So at that point in time, I felt like that was the important thing to do because you know that the situation Gabby was in was pretty bad. So I chose to give her full custody of Piper so I could get full custody of Gabby. So that's the only reason why I don't have 50-50 custody of all of my children, because I wanted my oldest daughter removed from the bad situation she was in. Otherwise, I would have. I had full custody of Gabby up until she was 18.
But you were in prison for part of that, weren't you?
Yeah, it doesn't mean I didn't have custody.
Where was she
I'm
living?
I'm in prison now. It doesn't mean I don't have custody still.
Right, I didn't say otherwise.
Okay.
I think that covered all of the questions that I had.
Okay, sir, do you have any statements you'd like to clarify or add anything there? You don't have to, it's just your opportunity.
Yeah, I'm just looking at my scribbles here real quick just to make sure.
Well, and anything that you're saying now should relate to Ms. Divish's questions as redirect.
Not really. I mean, we pretty much touched on everything there, you know.
Okay. Any further witnesses or exhibits?
No,
Sir?
not at all.
Okay. So the two of you are able to give closing statements. Yeah, I am gonna have to take the matter under advisement and issue a written opinion. I have an interview with your daughter at 4. So that's a component that I have to complete before we could make a decision. But in terms of closing arguments, are either of you interested in providing one, or this would be your opportunity, ma'am, so we'll start with you.
I would like to give a closing argument, please.
Sure, thank you.
I would like the court to take a look at all of the information that has been given and just give their best in thinking of what's best for my daughter, which I know that is what your job is, and I know that's what you're going to do. I guess I don't have a closing argument. I thought I did. That's all I wanted to say. I apologize.
Okay.
But I do have questions if you don't mind.
Yeah, I just have, I guess, one, but it's, you're looking to change joint legal to sole custody with you. Is that correct? Sole legal?
Yes, I am. That's what it's been for the last several years anyway.
And then I believe I asked you this already, but you're looking for you're okay with the transition plan set forth in your mediation agreement, but you would like to have supervised visits in there.
Yes.
As the visits, not just that you want that to be the visits.
Yeah, and he had said something about I didn't know that he would be able to choose somebody that was supervising the visits. I thought that I would be paying for a professional person to do that. So I guess I was unaware of how that process works.
Court has different options. I mean, sometimes the court will refer the matter to safe haven, an agency or an agency like that to supervise, or sometimes parties are comfortable with a person. I'm sorry to insinuate that safe haven isn't, they aren't people, but a person you can agree on is what I'm saying, an agreed on third party. Sometimes parents agree to have someone they know or someone they trust supervised. So you have options.
Right. So there are options and there's no reason for it to be held up or anything like that. So it's not like I have control over that kind of stuff. I can't just say you can't see your daughter because I don't agree to that person, correct?
Well,
Unless that's what your order said, right? Depending on what I decide, I guess at this point.
Yeah, I just wanted to make that clear because he was saying that I would be able to control that and I don't have any control over that, right?
I think that will depend on how I decide this case.
Okay.
So any further closing remarks?
No, sir.
Okay, sir, your opportunity.
Yep. Just to touch base on what you said about somebody, I guess I wasn't aware which way it went. I just know that when I was a kid and we did the handoff with my mom and my dad, it was through a mutual friend. So I just assumed, you know what I mean? Like, I don't know. I can't even think of somebody for an example. You know what I mean? If I were to say Nigel, for example, and you said no, like you see what I'm saying? That's what I was getting at when I said that. So kind of like I had mentioned a minute ago, Your Honor, what I'm worried about is like you had just said, it depends on how you rule. We both know joint legal means she has every bit of power and control over anything. If we do this agreement and the agreement that we had in order, if we go on with that, but she ends up with joint legal or joint physical custody, joint legal. I am sorry, full legal. I'm getting flustered, Your Honor. I apologize. Full legal. Then really, when it comes down to it, she can just say no. That is what it is. When you have full legal custody, you have that option. And I have to fight back into it. And that's really what I'm worried about. I'm not saying I plan on getting out and taking my daughter and going out to California for 3 weeks with her when I get out. That's not what I'm getting at. I'm really agreeing to step back into it. But I don't want that full custody thing held over. If we're going to be parents, then why does that got to be a thing? Like we've managed to do it this long. It's nothing but control at this point. And honestly, like I said before, I'm really nervous if this doesn't go well, what's going to happen to me next? I mean, it's pretty, and I even have a JPay message from her that says this is just a technicality. Well, if it's just a technicality, then why can't we just leave it as it is? So that's kind of it. And I mean, I'm going to put in there one more time. There is no way I would ever harm my daughter in any way, shape, or form in the ways that it is being insinuated. Just so that is very abundantly clear. And it makes me sick to think that you could think that I would do something like that to our daughter. So that's all I have to say, Your Honor. I appreciate it.
Thank you both. As I stated, I'll take the matter under advisement, issue a written. Go ahead.
One thing, I apologize. I did want to ask, when you talk with my daughter, is this going to be a neutral location, not where her mom's sitting there, not when I'm sitting there? Is this going to be a situation where neither one of us are around? Because I don't feel like it would be appropriate to put a kid in the stand in front of either one of her children or either one of her parents or with her mom in the other room even. Like, so I was kind of nervous about that because obviously I'm not thinking that she would coach her on stuff, but I don't want her right in the other room scared to say something thinking her mom is going to hear it. You know what I mean?
Understood. It's scheduled to be on Zoom, right, Ms. Divish?
I was going to ask you those details. Unfortunately, I cleaned off my desk and I can't find the paper that I know it's at 4:00, but I was under the impression we were doing Alzheimer today, but I called the court and asked for the information and they gave me your Zoom.
Here's what we'll do, just so we can, and this is a pretty common request. Okay, so what I'm gonna do is reschedule it so that I can arrange it to be in person, and then it'll be at the courthouse.
Okay.
And either of you, I mean, I see, ma'am, you're nodding. You're okay with that as
Yeah.
well?
Absolutely.
All right, and
Okay.
that sounded to me like what your
100%.
request was, sir. That should take care of it. I mean, in my opinion, that
I
takes care of that
appreciate that.
concern. I can tell
I
you,
do
I've
appreciate
done,
it.
since the pandemic, I've done a lot of in-camera interviews through Zoom and never had any issues, but I respect the request and I honor it, so I will comply with that request. And I'll get the in-camera interview rescheduled and we'll have it in person.
Well, guys, let's hear what you think about that while I get this next thing queued up. You're right, Rachel. We'll probably just do both. We'll start with Manning and we'll go from there. If you all would please let me know in the chat how much you would like to kick that guy down the road so that he could not do that again. That would be great. I'm just kidding. Honestly, I'm just that's just not nice, to be honest. Just not nice at all. Yeah. That was Matthew Hagan. I thought he dealt with that well, though. Better than some. Better than some. Okay. Let me just pull this up. Oh, I can fit right into there too. This will be a good one. Okay. Fit right in here. Well, maybe I'll take over the court reporters. No offense to the court reporter, but everybody else might be doing something silly. It's 2x, so I will slow it down. Thanks for the reminder, Viking. Even though that would just be normal sounding with Manning.
I'm still didn't put that name in my email. All right, Mr. Lomnick, Anthony Lomnick. All right, so we got this 2-1
Hold on, maybe I messed up. Give me 1 second. Judge Manning, you are just always keeping us on our toes. Always on our toes. That is what I knows. But it's okay because I do it live.
All right, everybody, gentlemen, I tell you what, we're gonna get through this as quickly as possible. But the number one thing for you to do is stay in your seat. I do understand that it's medical call right now, and that's fine. You can go out and get your meds. Don't keep going out and stand out there and talk to people, pulling on your clothes, tugging on your clothes, and walking out and hanging out. That's not what we're going to do, okay? Stay in your seat. Keep your head up. Don't put your head down. Don't lean over on there. Don't put your head like this. Don't pick at your nose. Don't pick at your hair. Don't twist your hair. Don't mash your zits. The camera is not a mirror. All right? We will get everybody in and out at the same time. Everybody here is muted. I can't hear you. Okay? 1 North, booth 3. You doing the first thing I said don't do. 5 North, booth 4. It's not a mirror. Don't fix your hair. Everybody, y'all look great. All right, gentlemen? We're just trying to get you out of here. So, and look at 7 North, booth 3, getting up and leaving. All right, so stay in your seats. We'll call you. We'll get you out of here as quickly as possible, okay? Today, this is what I like to call a you problem, gentlemen. We're addressing bond and bond only, okay? The reason you're on mute and you don't get to say anything is because there's nothing for you to say. It's a lot like first appearance, if you remember that. You're told what you're charged with. I address bond. Everybody on the calendar tonight is statutorily entitled to a bond. I'm going to hear from pretrial first, hear about your criminal histories. Then I'll hear from your public defender. Then I'll hear from the state. Then I'll make a decision. Everybody in here, you've got to give your attorney an address. Once again, back to the you problem. This is a you problem. If you don't abide by my bond conditions, you will be the one that gets arrested and goes to jail. Not your mama, not your girlfriend, not your fiance, not your baby mama, not your sister, not your grandma. It's your responsibility to get the notifications when they're sent to you. All right. Your public defender is going to mail you a copy of your bond condition and your bond order. Once they finish up today, it could pass you. It could show up in the mail and you're already made bond, hopefully. Okay. When you get out, ladies, you too, you need to call your public defender. 7 North Booth 3. You better sit down and keep your seat. Don't leave again, sir. All right. So make sure that you call your public defender and say, I need a copy of my bond order because I don't know what the conditions are. It may be stay away. It may be stay out. I may put an ankle monitor on you or something. I may give you things you need to do. You need to make sure that you do it. Once again, do not get up and walk out of that booth. If you do, your case will be reset and you will sit there for another 30 days or whenever we can get you back on the calendar. So pay attention. All right. Don't wave at people. Once again, new people, don't twist your hair, pick at your zits, do anything like that. Okay. So when you get out, make sure you do that. Also, 7 North, keep your head up. Don't put your heads down. All right. When I talk to you, I call your name, wave your hand so I can see where you're at. Once again, you're on mute. If I ask you a question, it requires a yes or a no, a thumbs up or a thumbs down. That's it. No matter how loud you talk, how much you scream at the camera, you're muted. I can't hear you. If they do come by and give you your meds, open the door, get up, and come back inside. Okay? Because if I call your name and you've stepped out, just move on to the next case. Now, also, if I call someone's name and you're like, hey, that guy's behind me, he's coming in next. Don't worry about it. We'll skip over it. We'll go to you. Okay? Gentlemen, we're going to start with the ladies first, done at ACDC, and then we'll get to you folks. Everybody good? Everybody hear me? Give me a thumbs up if you can hear me. Gentlemen. Gentlemen, you hear me? Thumbs up. Yep, 7 North can't hear. Miss appreciate
Judge, I'm gonna try to open up another booth on 7 North.
Okay. Look. 7. Go to another one. Go out, go to another one. All right, gentlemen just came in, keep your seat. No head down, no mashing zits, no doing anything like that, right? Don't leave. 7 North's gonna get in a new booth. All right, Maisha Brown. Is that who I got first? Oh, no, I got the other one. I'll get the other one. Sorry, I apologize. I don't know people, so I'm just calling the name. All right, let's see. I got.
Your Honor, I think I'm covering Maisha Brown for Latrivia, and I'm just waiting for the paperwork.
Okay. All right, we'll
Okay.
start with position 10. We got Bostic, we got Miss Young, and we got Madam Court Reporter. We'll start with position 10, Maya Campbell. And I've already started by email to Miss Willis, so don't worry about it because this one's at the top of my list.
Okay, thank you.
21 CP 2011330, Maya Campbell, 657 days without indictment, charged with aggravated assault. As of December the 1st, there is a $5,000 good bond. Pre-trial.
Judge, in regards, hold on, go back to my page. Sorry. 17 prior arrests, 5 misdemeanor, 1 arrest for probation violation, nothing further.
All right, go ahead, Ms. Safarasi.
Thank you, Your Honor. Like you said, Ms. Campbell has been in 657 days. That's without an indictment. We had a preliminary hearing back in March of 2022. The probable cause was found. Your Honor, she can't afford the current bond to set, so we really need to get it reduced. We are asking for UJR just on the sheer fact of the time that the state has had to move forward with this case and has decided not to. So we're asking for a UJR in this case. A little bit about Ms. Campbell is she is 46 years old. We have multiple addresses for her, but we have a solid address for her here in Atlanta. She spent her last 8 years in Atlanta. She has her godparents and family here. The entire family of her godparents are here. She is a high school grad. She has had some college at Spelman University where she studied fine arts and English. Prior to her incarceration, Your Honor, she was an actress. I'm not sure if you are aware, but she was in a show called In the House. That was with LL Cool J. She was also in some other shows and some music videos. And Your Honor, because of the time that she's been incarcerated today, we are asking for the UJR. If Your Honor is not open to a UJR, then we're asking for a bond not to exceed $1,000.
Do you know where she's going to live?
Yes, Your Honor, in Atlanta, but I would like to not due to
No,
this
okay.
recorded,
It will
I
be-
don't wanna-
it'll be in full-
I'll change the address, Your Honor. It is in Atlanta though, so. Fulton County.
Okay. All right, Miss Patton.
Hi, Your Honor. I'm apologizing ahead of time. My dog is screaming in the background right now.
That's
so if you
okay.
hear it, my bad. We have been 657 days without indictment. The concern here is that the defendant is a danger to community.
Hold on. 3 South, sit down. Booth 3 South, sit down. I don't want to see your rear end. Don't be pulling your pants up and down. Keep your seat. Gentlemen, I'm sorry, Miss Patton. Go ahead. I don't want to look at your nasty underwear. Go ahead, Miss Patton.
No problem. We're concerned about a possible danger to the community based upon her prior arrest. Also, worried about risk to the community based upon the nature of the crime itself. It seemed to be kind of random. I don't know that Ms. Campbell had a connection to him, so that is concerning that that type of action would be taken to someone she doesn't know. If Your Honor is inclined to reduce the bond, we ask that you keep the conditions put in place. I believe it's a stay away, and we would just ask that you do those. Nothing further.
All right,
And Your
yeah, we
Honor,
got
just to-
657 days. Miss Pinto or Miss Beck would be saying it like 40 times before either one of them carried on to anything.
Your
So,
Honor, Your Honor,
yes,
before
ma'am.
we make room, I just want to have on the record, we are looking into filing a speedy trial demand in this case because it has been so long. So we do want to put the state on notice of that today. And again, if she is such a danger to the community, I do not understand why she hasn't been indicted, as well as the fact she hasn't had any jail incidences, by the way. There's been no violent incidences to my understanding. She's had no issues at the jail to support the fact that she's still a danger. This case, again, it's an allegation. It is not a conviction. And so because of that, Your Honor, we just want to take that into account that this is not a conviction. She has no felony convictions as well, or no violent convictions to my understanding. So just want that for the record, Your Honor.
Okay. So we got no drugs unless prescribed, no alcohol, no weapons, no further contact with Marvin Scott. Let's see. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You can also leave for any kind of mental health treatment or addiction treatment. Looks like some of the previous arrests and stuff were for drugs. Stay away from the intersection of Parsons Street and Joseph E. Lowry. And before I enter in a mental health treatment facility, get a mental health evaluation and follow the recommendations. And make sure you put in that change of address before you leave the jail. That ankle monitor will be paid for by the county. I've already put your name in there, ma'am. $2,000 good bond. And Miss Safarossi, if for some reason she can't make that, email myself and Miss Patton, because this was at the top of my list. I've actually made the print in red.
Yes, Your Honor. I don't believe she can make that, to be honest with you. So I will be emailing you.
Okay. So if we have to, we'll just put this one back on another 30 days until I get something. But it's in red. I made it red print right there to Miss Willis. Miss Campbell, we'll see you in 30 days if you're not out. Best of luck to you. Maisha Brown.
Judge, before you go on to him, can you make sure that 7 North Booth 3, 7 North Booth 1, he can now hear?
7 North, can you hear now? Give me a thumbs up. 7 North. Thank you, sir. All right, so we got Maisha Brown, 23CP215530, 101 days without indictment. There is a $1,000 split bond, and there's $1,000 on the possession of drug-related objects. As of January the 18th, possession of cocaine with intent to distribute, receipt, possession, or transport of a firearm by a convicted felon or first offender, possession of a firearm during the commission of or attempt to commit certain felonies, manufacture, deliver, distribute, or possess with intent to distribute MDMA. VGCSA, possession of Schedule 1 or 2 controlled substance with intent to distribute, theft by receiving stolen property, possession of drug-related objects, VGCSA, possession of Schedule 3, 4, or 5 controlled substance, possession of marijuana, manufacture, distribution, or sale of marijuana, 15.5 grams of MDMA, 18.8 grams. Let's see, what is this? Hold on. 2 bottles of promethazine, 10.5 grams of weed, 8.5 grams of crack, and 18.8 grams of Adderall, all alleged. Retrial.
18 prior arrests, 2 misdemeanors, FTAs 2017 and 18. 2019 by shoplifting felony, nothing further.
All right. Go ahead, Ms. Bray. Ms. Bray. Ms. Bray. Woo-hoo. May have to say it one more time. Ms. Bray might have stepped away to get the paperwork. What about Jamaica Hickson? Ms. Hickson, we'll come back to Ms. Bray's client. Just stand
Your
by.
Honor, I'm so sorry.
No.
I thought
Okay.
I was off mute. I thought I was talking. Y'all didn't
Oh.
hear me.
I now say you probably said some very wise things. Try it again though, Ms. Bray.
Okay, let's try it again. So, she's 26 years old. She has 3 children. During the time she's been incarcerated, they have been living with her stepmother. Okay, she is currently enrolled in UEI, which is the Morrow campus, working towards her GED in a trade. Prior to her arrest, she was working for a labor staffing temporary agency. She is a lifelong Georgia resident. We have a valid address for her, which is 3266 Wellington Walk, Southwest, Atlanta, Georgia, 30331. She would be living there with her cousin. We got that information through her mom because we've been in contact with her mom. The amount of bond that she currently has, Your Honor, she cannot afford. So we are, I think it's 39,000. My math isn't the greatest, but that's
But
what
right
I
now
came
it's
up with.
right now, like I got a $1,000 split. Like no bond on everything else.
Okay, this might have been a suggestion then from
Okay, we'll take
the
suggestions.
trivia.
All right. Yeah,
So,
I think so.
I am asking for a UJR, of course, but I understand, the amount of whatever the drugs are, you cannot do that. But I am asking for a UJR with an ankle monitor and a curfew. And I'm asking that the exceptions for the curfew be school, work, childcare, court appearance, attorney visit, medical stuff, like the standard. That's what
Sure.
I'm asking for.
Okay. All right, Ms. Patton.
Quickly, Your Honor, Ms. Bray, did you get the 39,000 as a suggestion from another ADA?
Honey, I didn't really look at this as hard as I should have looked at it, but
That's fine. I just wanted to honor if a previous ADA had told you that, I was going to honor that agreement, but
yeah, so I don't have information that says a previous judge or person offered that. What I do have is that according to Judge Brasher's order, this is like the least it could be. That's my understanding of the information that I have. But I don't want it because it does not help me.
All right, go ahead.
Understood. Your Honor, on this case, the state has various recommendations. Obviously, one of them is not a UJR. Considering the defendant's prior history and her 2 FTAs, we're worried about her being a likelihood of reoffending and a likelihood of fleeing, being that she's had 2 FTAs. Would you like me just to go down charge by charge and do our recommendations?
Sure, that's fine. 3 South. Booth 3, just in the mirror. Stop playing with your hair. Go ahead.
For the possession of cocaine with intent to distribute, that would be a $10,000 good bond. For receipt, possession, or transport of firearm by convicted felon, that would be a $15,000 good bond. For possession of a firearm or knife during commission or attempt to commit certain felonies, that again is a $10,000 good bond. For manufacture, deliver, distribute, or possess with intent to distribute, that would be a $5,000 good bond. There's a $1,000 good bond on the possession and use of drug-related objects. That would remain the same. For the VGCSA, a $10,000 good bond. For the theft by receiving stolen property, $500. The subsequent VGSA, $10,000. And purchase, possession, manufacture, distribution, $5,000 good bond. let me know if you didn't catch that because it was a lot. And I did no math, so I have no
Okay.
idea what the
Good.
total was.
I'm not either. Ladies and gentlemen, that's why you need to listen. I don't know if you can do the math in your head, but at least try. All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1575 Joseph E. Boone Boulevard Northwest. No further contact with your co-defendant, Clarence Marsh, Marsh. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, job, school,
Childcare, can we throw in childcare?
child care, and yeah, and I said employment, as long as you provide the name of your employer, proof of employment, schedule, and the exact location you're going to be working. Now, what you need to do, ma'am, is if you go somewhere, like you got to take your child to the doctor, heaven forbid, you need to call the ankle monitoring company. Hey, I'm taking my child to this doctor at this address, okay? I'm giving you a hint that the state gets a printout every month of everywhere you guys go. Ladies, gentlemen, if you get an ankle monitor, so you can't really outsmart the ankle monitor. And then when you cut it off, you're going to be back in front of me. I'm going to be mad. It's just this vicious cycle, okay? All right. 10,000 count 1, 10,000 count 2, 10,000 count 3, 5,000 count 4, 10,000 count 5, 500 count 6, UJR jail on drug-related objects, 10,000 and 5,000. 10,000, 10,000, 10,000, 5,000, 10,000, 500, UJR jail, 10,000 and 5,000. Best of luck to you, sir.
And what's the amount of that bond? I mean, I know it's less, but you know.
You know how they do the math.
Like, I don't do the math either, Your Honor.
I know. 10, 10, 10, 30, 40, 50, 60, 6,500.
Okay.
All right, best of luck to you, ma'am. All right, Mr. Hickson. Thank you, South End, thank you, ACDC. So it's position 21, 22, CP 209,627. 321 days without indictment. There's $11,000 good bond as of January the 19th. Aggravated assault, obstruction of a law enforcement officer, and giving false info. Pre-trial.
In regards to Mrs. Hickson, extensive criminal history, 42 prior arrests, 12 misdemeanors, 3 felonies, 12 probation violations. The misdemeanors, you got a battery, simple battery, and a battery. Felonies, terroristic threats, robbery, theft by shoplifting. Currently, she's on probation for burglary in Muskogee, sentence 428-21. 5 years, nothing further.
All right. Go ahead, Mr. Young.
Thank you, Your Honor. Judge, we have secured Mr. Hickson a residency at Hope House. He has been interviewed, accepted, and there is a bed waiting for him, Your Honor. I think a review of Mr. Hickson's history as well as the current charges would seem to indicate that Mr. Hickson could use some help, Your Honor, to put it lightly, and we believe that Hope House can provide that help. Judge, Mr. Hickson cannot afford any bond at this point, so we would ask for a UJR specifically to Hope House. Hope House can, we can arrange the transport to it and everything, and Your Honor, I'd be happy to go on about Mr. Hickson and him as a person, but I think the most important thing right now is getting him into a facility that he might actually be able to get some long-term help at. Your Honor, I can provide the letter from Hope House to the court via email if the court would like to review it. Judge, again, just to reiterate, we are asking that the court recognize the fact that Mr. Hickson has been in custody for almost a year at this point, and we have a very limited opportunity to get him into this facility before the bed is gone. And we're just asking for the court to help us out on this one, I guess, Judge.
All right, what says the state?
Yes, Your Honor, we would object to a UJR in this case. Considering his prior history of 42 arrests, there's a substantial likelihood that he'll reoffend. I also, though, would like to know a little bit more about Hope House. If I could ask Mr. Young that, would that be appropriate at this time?
Go ahead. Tell her about Hope House, Mr. Young.
Sure, Your Honor. Judge, Hope House, it's a live-in facility that Mr. Hickson would receive round-the-clock care for. That includes counseling, group, both individual and group. It involves substance abuse treatment where necessary, mental health treatment where necessary, as well as life skills and potentially job placement. Mr. Hickson would stay at the facility If he were to leave the facility, I presumably any sort of bond order from this court, UJR otherwise, would require Mr. Hickson to stay at the facility. So if he were to leave for any reason, of course, that would be violative of that bond, and we would be back here. And Mr. Hickson fully recognizes and understands that this is one of the last chances that he has to turn things around. Again, I would be happy to send literature to the state if the state would like to learn more, but I do know that this court is very familiar with Hope House and the good that it does for the community.
Is the Bell Project going to help him at all?
Your Honor, I don't believe so. We've been in communication with them recently, and they've been hesitant with a few of the cases that we've sent over.
All right, go ahead, Ms. Patton.
Nothing further from the state, Your Honor. Obviously, it's at the court's discretion. But I do appreciate Mr. Young for going through that detail with me about Hope House.
All right. No drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, attorney visits, employment, as long as you supply the name of your employer, proof of employment schedule, in the exact location you're going to be working. Previously, it said stay out of Fulton County, so I'll take that off since you may live at the Hope House.
Thank you, Judge.
Stay away. Let's see. Stay away from 600 Spring Street. No further contact with Anthony Smith. So I got. All right. 4,500, 100, and UJR jail. 4,500, 100, and UJR jail. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Young.
Thank you, Judge. Your Honor, that concludes my business. May I be excused?
Uh-huh.
Thank you, Judge.
Your Honor, this is Amy Cole. There's just a message in the chat that Mr. Little, position 16, was transferred to DOJ custody. That's my only position on this calendar. I was wondering if I could be excused.
Oh, yes, ma'am.
All right, thank you, Your Honor.
Thank you.
Just so I'm clear, she doesn't want that reset for to waive his.
You want to waive his appearance or no?
Your Honor, I'm gonna refile. He has 2 other cases. I'll just refile a bond and have them both heard together.
Okay, sounds good. Thank you. Have a good evening.
Thank you.
Your Honor, do you want any language in there for Mr. Hickson about the Hope House? On his 24-hour exception?
Right. Yeah, if you don't mind, put some language in there about the Hope House. Participate in any programs at the Hope House, etc.
Okay.
All right, thank you. Let's see. What about, right, so Larry Little's removed. I'll still include that name, Mr. Little, on my email. But all right, Mr. Lomnick, Anthony Lomnick. All right, so we got position 2, 21 CP 204227, Anthony Devon Lomnick. Here's another one. $10,250 good bond as of January the 24th. 540 days without indictment. Obstruction of law enforcement over an ag assault. Pre-trial. Anthony Lomnick, position 2.
I got 15 prior arrests, 7 misdemeanors, 2 arrests for probation violation, possible open case in DeKalb from a February 16, 2020 arrest for entering auto and criminal damage to property. Nothing further.
Go ahead, Ms. Bray.
Your Honor, as you said, 540 days. I want Your Honor to take into account, we did a preliminary hearing on June 27th of last year. Okay. We had a bond hearing before Your Honor on August 4th of 2022. Then we ended up having another bond hearing before Your Honor on January 24th of 23. The bond was reduced to $10,250. We're back, Your Honor. He's been in custody since November 4th of 2021, and nothing has happened on this case. I am asking Your Honor to reduce his bond substantially, preferably to $5,000. Maybe I can get him out through the bail bond project.
Do you know where he lives?
The state has not indicted it since 2021.
Do you know where he'll live, Ms. Bray?
Hold on. Let me find it. I knew you were going to ask that. 209 Griffin Street, Lawrenceville, Georgia, 30039. That's his grandmother's house.
Is that where you'll live, sir? You gonna live with your grandma? Thumbs up or thumbs down? Okay, thank you, sir. What says the state?
Your Honor, we would object to a reduction in the bond that's been listed. I understand that it was already reduced at one point in time. Also, I believe he's had an incident while he's been incarcerated. The likelihood of reoffending, if he couldn't even stay out of trouble while incarcerated, that causes us some concern. Also, as I've mentioned before in this court, anytime that there's an incident with an officer where they're resisting arrest or doing something to endanger a law enforcement officer, that gives me concern as to whether or not they're going to be able to operate in society if they're not, listening to authority.
Okay, so, Your Honor, I must speak. Miss Patton, ADA Patton, I don't have a problem with you. But if you have been paying attention to the news and what's happening at Fulton County Jail, then you know plain as well it's overcrowded. People are stabbing each other. They're creating riots. They're doing all kinds of stuff. So you can be an innocent person. And I always think that my clients are innocent people. You're put in a place that you were not trying to go. But when you get there, stuff is happening and you must do whatever the hell you need to do to protect yourself. So the fact that there may have been an infraction or something taking place at the jail should not be used against Mr. Lomanick, who has been in custody since November of 2021, and your office has done nothing.
I think there was some amens from like 4 South Booth 3, 4 North Booth 3.
I'm just saying, Your Honor, if I'm locked up in Fulton County Jail, somebody approaches me, they're trying to attack me, they back me up in a corner. Guess what? My little behind will do whatever I need to do to come out of that corner.
I understand.
I have a right to do that.
That's never gonna work as an excuse for me.
And I don't care if it doesn't.
I understand about the 539 days, but as you know, the state has a statute of limitations and we have still time to indict this case. And it sounds like there has been movement in terms of preliminary hearings and probable cause was found. I understand what you're saying and can appreciate it. However, my position is still the same.
ADA Patton, the preliminary hearing was held in June of last year. Your office has done nothing.
Miss Bray, has there been any contact with the alleged victim? I mean, Miss Patton? He's on the 3rd floor. Was there an ex parte or anything done there?
No, Your Honor.
No need or?
No need, because he plainly knows what happened. We did the prelim. He plainly knows what happened.
All right, so we got no drugs unless prescribed, no alcohol, no weapons, no further contact with Curtis Smith. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County unless you're here for court or to see your lawyer.
$100. Can we get an ETA on when this case may be indicted, since he's been sitting in since November of 2021?
I put it on my email to Ms. Willis. So I got
Thank
100
you very much.
100 on count 1, 4,900 on count 2. Best of luck to you, sir. You can leave the booth. All right. What about Kareem Harris? No Kareem Harris yet. What about Leon Parker? No hands. What about Sean Johnson? All right. So we got position 19, Bostic 22, CP 212621. 216 days without indictment. There's a $44,000 good bond as of December the 19th. Terroristic threats and acts. Willful obstruction, misdemeanor, simple battery against a peace officer, simple battery against a peace officer, and simple battery. Free trial.
Extensive arrest history, 54 prior arrests. Criminal damage to property, theft by shoplifting, simple battery, simple assault, criminal damage to property in 2020. Repeat offender, at least 6 felonies, aggravated assaults, entering auto, terroristic threats, couple of FTAs, couple of arrests for probation violation, nothing further.
All right, go ahead, Ms. Correa.
Thank you, Your Honor.
You're in the back
just to
seat of the
clear-
car, right, Ms. Correa?
I am in the back seat of the car. I am with
Outstanding.
some of my colleagues.
Oh, okay.
We're on our way to support a different colleague. But in regards to Mr. Johnson, he is 49 years old and a lifelong resident of Atlanta. He has now been in custody since September of 2022. His preliminary hearing was on December 19th of 2022, and this is his first hearing since that preliminary hearing when that bond was also set. The address that you see reflected in Odyssey is a good address for him. That is where he resides with his roommate, Shannon Branch. Mr. Branch actually came to Mr. Johnson's preliminary hearing in support of Mr. Johnson and has continued to maintain contact with me to have a better understanding of the case and where it currently is as it falls. So Mr. Johnson does have good ties to the community. Aside from Mr. Branch, his father, Mr. Eugene Johnson, is also in the Metro Atlanta area and also has been in contact with me regarding Mr. Johnson and this case. Mr. Johnson does have his GED. At the time of his arrest, he was working with the Center for Employment Opportunities. Through them, he was employed with the City of Atlanta in their sanitation department. This is the CEO program is a nonprofit organization that our office also partners with, helping people maintain steady employment and professional services related to, maintaining steady employment. At this time, since he's been in custody since September of last year, and his prelim is now from 4 months ago, we are asking the court to please reduce his bond to $10,000. Thank you, Judge.
All right, now on here, on his previous bond order, it said must reside at Delmar Lane. Is that still where you're gonna reside, sir? All right, what says the state?
Okay.
He said yes. Go ahead. What says the state? I mean, he nodded his head. What says the state? Ms. Patton?
Your Honor, we would object to a reduction in bond, considering the likelihood to reoffend with his prior arrests. I have the numbers as they're broken down already, if you would like me to provide those.
I got it.
Okay.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from all Wayfield locations. Let's see. You gotta have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you provide the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay away from 100 Edge. Oh no, that's the wrong one. 100 Edgewood. As long as you provide the location you'll be working and provide that. Let's see. Proof of employment, name of employer, schedule, the exact location you'll be working. Sorry, I messed up my groove. And provide that in your schedule and the exact location to the ankle monitoring company and to your lawyer so they can provide, so she can provide it to the state. Must reside at 2924 Delmar Lane in Atlanta, Georgia, 30311. So I'll do 8,000, 8,000, 1,000, 8,000, 8,000, and 1,000. Best of luck to you, sir. And I just added his name to my email, Ms. Correa.
Your Honor, that curfew was.
Sweet Canadian water I have, but yet still like a $400 or $300 rookie filter, I guess it is. Anyways, let's continue watching. I love Judge Manning so much. I just made some pink lemonade. The rice is going, and the Instant Pot has 36 minutes left on my Popeyes copycat beans.
From 8 p.m. to 6 a.m. Are we changing it to 24?
Yeah, just do it 24 hours. That way he can just call when he needs to go somewhere. He can let them know.
Yes, ma'am. And you did further contact with Anthony Andrews and Melissa Carlisle.
Oh, yeah, thank you. You're right, man. You're so good, Michelle. No further contact with Anthony Andrews and Melissa Carlisle. Best of luck to you, sir. You can leave the booth. All right.
Your Honor, could I selfishly request for my next client to go, just so my colleagues in this car are not also in Zoom court with me?
Okay, who's your next client? Let's see. Oh yeah, Mr. Watkins. Jabari Watkins. Mr. Watkins, 208 days without indictment. There's a $10,800 good bond. 22 CP 212-881. 208 days once again without indictment. November the October the 3rd was a $10,800 good bond. Possession of firearm by a convicted felon, unlawful entry into MARTA, willful obstruction, misdemeanor, reckless conduct. Pre-trial.
Just a moment, please. In regards to Mr. Watkins, 6 prior arrests, 3 arrests for probation violations, 2 convictions for purchase, manufacture, and sale of marijuana in 2017. Nothing further.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. Mr. Watkins is 23 years old. We have verified the address on file. That is where he's been living with his girlfriend. While he was born in New York, he has spent the majority of his life in Georgia since childhood. At the time of his arrest, he was gainfully employed with a landscaping company called Cut Buddies. Prior to this arrest, he had worked with them for 2 years. He has maintained a good relationship with his employer and does expect to be able to go back should his bond be reduced to something he and his family can afford. He does have a 1-year-old daughter. He missed her first birthday while in custody. Additionally, Your Honor, he is a self-taught pianist. He maintains his own YouTube channel where he composes and performs his original scores for various types of music. And that is something that he intends to pursue professionally upon, bonding out and reestablishing other employment as well. His bond has not been reduced since he had first appearance. Judge Mann heard this preliminary hearing in January of this year, January 12th. At this time, I'm asking Your Honor to consider reducing this bond to a $4,000 bond. Thank you, Judge.
And it's Pine View Terrace, right, sir? Thumbs up, thumbs up. All right, what says the state? Ms. Patton?
Your Honor, the state would be amenable to reducing to a lower bond. I have some numbers for the possession of a firearm by a convicted felon, a reduction to $5,000, and the reckless conduct, a reduction to $1,000. So I actually believe it's a little higher than what Ms. Correa is asking for. However, this defendant has had a firearm by a convicted felon, so we are still worried about the danger to the community, but we are amenable to a reduction in this case with the conditions of an ankle monitor, as Your Honor generally does. So I'm on about it.
No further contact with ALLIA, last name Christie.
Okay, you guys can rule it back and figure out how long he's been in jail, first of all. And that, because look for a channel that hasn't been updated in a while, quite obviously, because he's been in jail. That's so sad, partly, but also like his little piano fingers. I bet. Oh, I've told this story before, but I didn't have a piano when I was a kid, but I took piano lessons and they gave me tennis balls to hold to practice. So I bet I'm guessing that he did not practice with tennis balls, which is why his channel is not about court in the kitchen. It's about piano stuff. Oh, God.
CHRISTIE. No drugs unless prescribed, no alcohol, no weapons. Stay away from all MARTA property, sir. That means if you walk by a bus stop on Peach Street, you can't sit down at that bus stop and tie your shoe. That's a violation of your bond condition. You got to walk past that, sit down on the curb and tie your shoe, okay? Stay away from 70 HE homes. And you have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. Sir, you have a 1-year daughter at your house. You have that presumption of innocence. What you're teaching her right now is what she should expect from men in her life. When you get in trouble, you're showing her that's what you should expect. And you got that presumption of innocence. So, sir, do this for your little girl, okay? Make that promise to that little girl. Okay, I got you, sir. So we're going to do 4,500 count 1, 100 count 2, 500 count 3, and 1,000 count 4. Best of luck to you, sir. Go home and take care of your daughter. I don't do no math.
Judge. May I be excused?
Yes, ma'am. All right, let's see. 4,500, 100, 500, and 1,000. Yes, ma'am, Miss Correa. Now switch, let somebody else drive. You drive and let them go. All right, Carl Sinkfield. Mr. Sinkfield. Nope, no Sinkfield. Oh, you got Sinkfield. Okay. Position 321 CP 204313. 540 days without indictment. Carl Sinkfield. There's a $13,000 good bond as of January the 24th for terroristic threats, 2 counts of aggravated assault. Rah!
In regards to Sinkfield, 16 prior arrests, 1 arrest, 2 arrests for probation violations, 4 misdemeanors, a simple assault, simple battery, family violence in 09, aggravated assault in 2014. Nothing further.
All right, go ahead, Ms. Bray. You still on mute, Ms. Bray.
I'm sorry, Your Honor.
Okay.
I'm trying to keep up. You go fast.
I like to
I know.
put everybody back on the.
Okay, so you've already said the most important part. 540 days in jail. The case has not been indicted. We did the prelim on July 14th of last year. At that time, the state was on notice of what evidence they had against my client. It was brought out to the court before Judge Drake, I believe, that one of the alleged victims is no longer here. She is deceased. I brought it out to Judge Drake. The DA was Assistant DA DeAndre Royals, who said, hey, when this happened, this particular victim went across the street, spoke to someone immediately after it happened. So therefore, they were not going to dismiss one of these charges involving this particular victim. This particular victim was his mother. So, but she's deceased. She died in December of 2021. The case has not moved, Your Honor. I've argued bond before you before. I did it on January 12th of this year. I did it again, January 24th of this year. And here we are in April and nothing has happened. I know that Your Honor has placed his name in case on your list and sent it to Madam Willis. Nothing has happened. So I am requesting that the bond be substantially reduced from 13,000, get it down to 5,000 so that I can at least try and go through the bail bond project.
Where's he going to live? Before I put stay out of Fulton County.
Wait, because his home is in Fulton County, if I'm not mistaken. Hold on just 1 second.
Are you going to live in Fulton County, sir? Thumbs up or thumbs down? He said thumbs down.
Okay, so the address I have is 3296 Clifton Farms Drive, Decatur, Georgia. Is that where you will live, Mr. Sinkfield?
Thumbs up. He gave a thumbs up.
Okay, so that's where he will be, which is DeKalb.
Right. All right. We know this ain't DeKalb County. All right. So
if we can get it down to 5, I can try and go through the bail bond project, Your Honor.
Sir, I'm sorry that you were in jail when you lost your mother. That's a very hard loss. I'm so sorry about that. Go ahead, Ms. Patton.
Yes, Your Honor. I'm sorry. It took me a minute to get to the mute button. The state would object to a reduction in bond. That's reasonable and appropriate considering the nature of the charges. $13,000 good bond is, fair and reasonable, and he does have a bond. There's a significant likelihood to reoffend based on his previous history. Nothing further from the state.
All right. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, attorney visits, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County unless you're here for court or to see your lawyer. Let's see. Stay away from 4333 Scott Circle and East Point. No further contact with Rachel Cooley. Once again, sir, I apologize, and I hate that for your mother. 2,000, 3,000, and is that, I don't know which one has Miss Sinkfield as the alleged victim. But I'll make that one 1,000.
Your Honor, I'll look at I'll look at the,
Okay, yeah, make the one against Miss Sinkfield so she's deceased, 1,000, 2,000, 3,000, 1,000. That income honor be paid for by the county. Best of luck to you, sir.
Thank you, Your Honor.
Thank you,
And
Ms.
Judge, if I could, just very selfishly, similar to Miss Correa, could we do, Keith
White,
Von
who's
White?
next? Who's next?
Were you gonna call him next?
He's on my list. Thank you, Miss Bray. Thank you, Mr. Sinkfield. You can lead the meeting. All right, Kewan Wright. White, where you at, Mr. White? All right. All right, this is position 11, Boss Dick, 22 CP 207603. Kewan Dimitri White, 405 days without indictment as of January the 26th. There is a $90,000 good bond. Ag assault, robbery, possession of firearm during the commission of a felony, discharge of a firearm. Discharge of a firearm near a public street or highway, simple battery, and terroristic threats and acts. Free round.
On the prior arrest, another feather.
All right, go ahead, Miss Bassett. 405 days.
Thank you, Your Honor. 405 days. I will say I have had this case for so long that I forgot his file at my office and I don't need it because he's been my client for that long. As you said, the bond is $90,000. He is unable to make that. I would note that we had a preliminary hearing for Mr. White back in September. Case is still unindicted, obviously, or we wouldn't be here. I will say I understand that the charges sound serious, but upon reviewing the case and after conducting a prelim, I will say, I don't want to get too into the facts because I don't know that the YouTube audience needs to hear Mr. White's business like that. But it just does not add up. Like, I'm reading the report, I'm hearing the officer's testimony, and I'm like, this is not how things happen in real life. And so I know that that's not an issue for today. It's an issue for later, but we can't get to later until the state does its job. Mr. White is from the Atlanta area. He has family locally. I have spoken with them numerous times. He was a senior in high school when he was arrested, and he does want to finish. He has a place to go. He has a place to be. He's going to stay with his family. He has goals to keep him busy. I don't expect that he's going to be in any trouble. He is asserting his right to a speedy trial, and I am in the process of drafting a constitutional speedy motion to dismiss. So I wanted to put the state on notice of that. And for today, we are asking for a $45,000 good bond.
All right. He's going to live in Union City?
Yes, Your Honor.
Okay. All right. What says the state?
Miss Bassett, just quickly, is he living with his parents?
That's my understanding.
Okay. We're amenable to a reduction in bond, and that's honestly only based upon speaking with the victims. The nature of the charges are very serious, but in terms of the aggravated assault would be reduced to a $10,000 good bond. That would be for both of them. The robbery still would be a $10,000 good bond. Possession of a firearm, still $10,000, and discharge of firearms near a public.
That's not Jessica Blanche. It's Jessica Blanche's evil, or not evil, I don't know, twin sister, Caitlin Bassett. She's also going by a different name. I love hearing about all your guys's, all your TV shows that you liked. I will tell you something. I really liked Eureka, the TV show, and also Burn Notice. Yeah. Oh, and Black. What was that one? Black Orphan Black. Ugh. That was insane.
Highway reduced to 5,000, simple battery reduced to 1,000, terroristic act or threat reduced to 2,000. And I didn't do the math, so I'm not sure if that meets your $45,000.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Also, school or GED. So you just got to provide proof of enrollment and that you're actually going. No further contact with Travis Davis or Cooley, Coley Carter. 10,000, 10,000, 7,000, 7,000, 5,000, 1,000, and 2,000. Best of luck to you, sir. 10, 10, 7, 7, 5, 1, and 2. Best of luck to you, sir.
Thank you, Judge. And that would conclude my business for this evening. May I please be excused?
Yes, ma'am. Have a good evening.
You too.
All right, Ms. Braid. Let's see. Gordon Broussard. You got Mr. Broussard. All right, There we go.
Was that to stay out of Fulton County for Mr. White?
Oh, no, I think he lives in Fulton County. He lives in Union City.
Okay, thank you.
All right, thank you. All right, this is 22 CP 210312. This position for Bostic, Gordon Broussard, 302 days without indictment, $75,000 good bond as of January the 20th. Possession, manufacture, distribution, sale of marijuana, possession of controlled substance in Schedule 2 with intent to distribute, possession of scheduled controlled substance Schedule 2, possession of methamphetamines with intent to distribute, trafficking in MDMA. Pre-trial.
14 prior arrests, 3 arrests for probation violation, at least 3 felonies, but 3 felonies. Took a first offender on a purchase, manufacture, and sale of marijuana in 2010, 2011 theft by shoplifting, 2016 Schedule 4. Currently on probation in Spalding for unauthorized use of prohibited item. 12, 15, 21, 5 years for arrest for probation violation. Nothing further.
All right. Go ahead, Miss Bray. Where's he gonna live? You're on mute, Miss Bray. Wait, where'd she go? Bray. Where did Bray go? Oh, Bray. She get kicked off Bostic. I don't think I see her.
I don't think I did see the new leverage. Man, the old leverage is so good. And Psych was so good too. Oh man, so good.
Let's see. She's usually quick. Let's see. Second, so she can jump back on. Since we just read through all of that.
Also, Warehouse 13. Everybody's that show.
All my reading skills for nothing.
See?
I have to work up to read.
I know, you've been practicing. You've been doing good, Bostic. You got stick figures or pictures on there?
Yes.
That's what
I
a
have to
real
take
boss does.
breathing and all that so I don't stutter.
Let's see.
Somebody just came on.
At the oh no, that's Kennebrew. Come on, Bray. I just
No, she was already on here.
Yeah. Ah.
Oh, ER is an absolute classic, Lenny. Absolute classic.
Maybe
Scene
she
episode,
appeared for
formative.
All right. Come on, Bray. One more second. Let's see, I was just writing this down.
Boston Public Avenue Appeal.
You got her number, Bostic?
I texted her already.
I did too. All right, let's see. Well, that's hers too. All right, what about Harold Moss? We'll be right back as soon as Miss Bray gets on. And she got kicked off, I think. Wait, yeah. All right, Harold Moss. So we got his position 14, Bostic, 23, CP 215, 239, 112 days without indictment, no bond on aggravated assault against a law enforcement officer. Rah!
13 prior arrests, 5 misdemeanors, 2 felonies. This is in Georgia. Criminal cruelty in the first, burglary, robbery, 02, 2016, theft by taking, 1 arrest in New Mexico, 1 arrest in Tennessee. In Tennessee, a very old misdemeanor, I believe. Nothing further.
Your Honor, I'm here on behalf of Ms. Rosenhuber.
Okay, go ahead.
Right, Mr. Moss has been in custody for 111 days without indictment. He is currently on a no bond status, so he is legally entitled to bond for today. We are asking for a $10,000 good bond to be set so that he can go to the hold in Arizona and seek treatment. A few facts about Mr. Moss. He is 46 years of age. He is a lifelong Georgia resident. He does have a valid address on file. It looks to be in Cobb County. He did graduate from high school, and he also earned an associate's degree from Fort Valley State in business administration. He does have his quality insurance certificate, and it enables him to do engineering work without a full engineering degree. So he is currently unemployed, but he will be able to seek employment upon being released. We are just, again, asking for a $10,000 good bond to be set on his case so that he is able to go to his hold and to also seek the treatment that he needs.
All right. Let's see, Ms. Patton, according to this, let's see. Place his vehicle reversed, then place getting driving towards the officer in a manner which he's attempted to run him over. Looks like it was a traffic stop. What do you say? Have you spoke with the officer?
Your Honor, I reached out to the officer. I haven't heard back from him yet. He'll probably text me as soon as I just said it, or as soon as we get off here, because that's Murphy's Law for me. The state's asking for a $20,000 good bond in this case. The nature of the crime itself, also due to the fact that he is and does have charges in other states, the risk of fleeing and the likelihood of reoffense is substantial. That being said, again, a $20,000 good bond is recommended. Nothing further from the state.
All right. Let's see. No drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. That means, sir, you don't stop for gas, you don't get a flat tire, you don't get lunch, you throw a snack in the car. Don't stop at Chick-fil-A, don't stop at Chipotle. Let's see, what else? Fellini's Pizza, have Fellini's. Don't get a Fellini's Pizza in Fulton County. All right? You're going to have ankle monitor. No, actually, you're going to have one of the Teletrix monitors. Miss Young, Teletrix, paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be driving. You'll be working. And no driving during the pendency of this case until somebody modifies your bond. If they don't modify your bond, you cannot drive. No further contact with Officer John Hurst, Hurst, unless it's in official duties. Sir, you go straight to Cobb County. You stay in Cobb County. Court. Lawyer, that's the only reason you come to Fulton. $45,000 good bond. Best of luck to you, sir. You can leave the booth. No, Miss Bray, you back. Miss Bray, take yourself off mute.
Your Honor, I'm back. I'm trying to get onto the part that lets me pull up the booking screen.
Did you
That's
hear
my issue right now.
Did you hear Bostic?
Which case is it? I'm sorry.
Oh, Broussard Gordon, did you hear his
Yes, I did, Your Honor.
Right.
Hold on. I'm sorry.
Allegedly 29 grams of fentanyl, 61 grams, 175 grams of meth, 89 grams of weed, and alleged 61 grams of, is it MDMA?
But Your Honor, he's been in jail 302 days.
And being in jail 302 days.
Back in October. And nothing has happened. And the amount of drugs they're saying that they're alleging he had, those are the drugs that should have been tested by now. I understand they sent out an email saying, the small amounts, they're not testing them. This is allegedly large amounts. So why haven't they done something since October of last year? They've done nothing. And my client has been sitting in jail 302 days of this year. So I want his bond reduced substantially, Your Honor, because they've done nothing. And they already know what they have. What evidence they allegedly have, they know about it. So they need to do something because he's just sitting.
Do you know where is he gonna live in Fulton County?
Hold on.
Sir, you give me a thumbs up. Are you gonna live in Fulton County? Thumbs down. Okay.
He said thumbs down, right?
Right, he said thumbs down.
So it's 4850 Chesterfield Court, Sewanee, Georgia.
All right, that's right. In Swanee. Thumbs up. All right, he gave us a thumbs up. Go ahead, Miss Patton.
Yes, Your Honor. The state would object to a reduction in bond. He does have a bond in place, which is what he's statutorily, required to have. He does have one. I believe it's 10, 10, 10, 15, 30 on the numbers. We would ask that you keep that in place. It's reasonable considering the nature of the felonies that have been alleged. Also, the fact that he has 14 prior felonies. And I believe, and I might be crossing it with the previous case just because we had a little bit of a break, so forgive me if I'm wrong. Okay. I believe he had charges in another state as well. But pretrial can confirm that for me.
Bostic?
Yes. I don't know about another state. There's a
Broussard, I don't have anything for another state.
Okay, I might have been Might have been
Sorry, I
from
didn't
the
get that,
last
Miss
case.
Bostic.
That was the other.
Hold up,
I'm
wait,
sorry, we're talking over
wait.
each other.
Wait. All right, get it from Miss Gandy. Respond, Bostic.
Broussard doesn't have anything. That was the person we read while Ms. Bray was gone.
Okay, but I was only gone because y'all kicked me off.
I wasn't saying that as something against you, Miss Bray. I was just trying to correct Miss Patton.
I know, boo-boo. Okay.
Miss Bray, you didn't pay your internet bill. That was the other one, though, Miss Patton. It's easy to get it confused, so go ahead. And it looks like, yeah, he's going to live outside of Fulton County.
My apologies for the mix up, Mr. Broussard. But that's all from the state.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 5570 Roswell Road in Atlanta, Georgia. Stay out of Fulton County unless you're for court or to see your lawyer. You're going to have a Teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, or employment. As long as you supply the name of your employer, proof of employment is scheduled in the exact location you're going to be working. The only reason you come to Fulton County once again, sir, is court or to see your lawyer. Fill up with gas. Make sure you got air in your tires. Don't run out of gas. Don't get a snacks. Throw a pack of crackers in your car. All right. Let's see. Make sure we're good at that. All right, so we're going to go 5,000, 5,000. 10,000, 10,000, and 20,000. 5,000, 5,000, 10,000, 10,000, 20,000. Best of luck to you, sir. You can leave the booth. I've already put that on my email. All right, let's see. Kejwan Raglan, Mr. Raglan. All right, there you go, Mr. Raglan. Position 9, Bostic 22, CP 214739. 134 days without indictment. Got aggravated assault, criminal trespass, no bond as of December the 16th. Free trial.
In regards to Raglan, 4 prior arrests, 1 misdemeanor. 2 misdemeanors, my bad. A 2020 simple battery, family violence, and obstruction, and currently just sentenced to a battery, simple battery, 3/21/23, 12 months. Victim Robin Calhoun. Nothing further.
All right, go ahead, Ms. Bray.
Yes, Your Honor. Mr. Kwan Raglan is 19 years old. He has a stable address, 1555. I believe it's McLeodon Avenue, apartment 3, Atlanta, Georgia, 30307, where he lived with his cousin, Starlet Thompson. He's born and raised here in Atlanta. Your Honor, he's been in jail on this case since December 15th. Of 2022. I was assigned to him on December 16th, the next day. Nothing has happened on this case, Your Honor.
All right. Go ahead, Ms. Patton.
Yes, Your Honor. Mr. Raglan is statutorily entitled to a bond, but at this time, the state would recommend for the aggravated assault charge a $30,000 good bond, for the criminal trespass and damage to property, a $5,000 good bond. The nature of the crime is very serious, and we're concerned about there being a possible danger to the victim in this case, whose name's Alexis Haley.
Right, says it's his sister.
Correct.
Correct, Your Honor, but I believe it started based on an argument with the grandmother. And the one person who has called me continuously since December of last year is the grandmother. She's concerned about her child, her grandchild. She wants him out. She understands that there are other things going on. Now, those other things do not at this point arise to the level where I would do an ex parte, but she recognized what it is.
Okay.
And she would like for him to have, a normal bond, something, because 9 out of 10, she's going to be the one. Other family members, they're going to be the one to post his bond and get him out.
All right.
And he's been in all this time. So, the state needs to put up or shut up.
All right.
Much.
No drugs unless prescribed, no alcohol, no weapons. No further contact with Alexis Haley, Haley. Obviously, if she calls to speak, does some sort of affidavit, we can change that, but you can't have any further contact with your sister. Stay away from 139 Dahlia Avenue, Dahlia Avenue Northwest. You're gonna have a teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, or employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You gotta supply that to Miss Bray and to the ankle monitoring company. $20,000 and $5,000. Best of luck to you, sir. You can leave the booth. All right, Demarest Lee, Mr. Lee. All right, this is a Miss Bray night.
I know. I don't even know what happened, Lord Jesus, but it's my night tonight.
All right, let's see. This is position 5, Bostic 22 CP 211977. 238 days without indictment. There is a $17,100 good bond as of January the 19th. Possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, possession of firearm by a convicted felon, possession of firearm or knife during the commission of or attempt to commit certain felonies, possession of drug-related objects. Free trial.
Extensive criminal history, 27 prior arrests, repeat offender, at least 6 felonies, 2 misdemeanors, 1 arrest for probation violation, currently on probation for aggravated assault, 2014. What? Battery, family violence, a 20-year sentence, nothing further.
All right, go ahead, Ms. Bray.
Yes, Your Honor. So Mr. Lee has been in for the amount of time that Your Honor has said he's been in. He came in to me on September 2nd, which means he was probably arrested September 1st. We did have a preliminary hearing on December 8th of 2022. So we're talking back in December. We're almost 5 months later. On Monday, it's 5 months later. Nothing has happened on this case, Your Honor. He has 5 children, 23, 22, 17, 16, and 15. He is a lifelong resident of the state of Georgia. Prior to his arrest, he was working for Weldon Towing Company, towing cars, and he was also doing home renovation on the side. That was his work experience for the last 20, 25 years. I'm not understanding why nothing has been done on this case. If he's a danger to society, the DA's office should have done something. They have done nothing. I was before Your Honor. Wait a minute. I want to say January 19th, 2023. Maybe that's when we got the current bond that we currently have.
It is.
Okay. And here we are 3 months later. Nothing has happened. This is a case. Well, all of the cases I have on the calendar, I would like for Your Honor to put them on your list and send them to Madam Willis. And I do believe most of these you have already sent to Madam Willis, but nothing has happened.
Looks like it was allegedly 10.4 grams of coke, 11 grams of weed, 14.2 grams of crack. All right, Miss Patton.
Yes, Your Honor, the state would object to a reduction in bond. His bond is reasonable at around $17,000 good bond. I didn't do the math as well here. If Your Honor is inclined to reduce his bond, we would ask that the same conditions be put in place. I would like to point out to Your Honor, though, that there's also a significant likelihood of reoffending considering his extensive criminal history that was read out by pretrial.
All right, no drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay away from 942 Lucille Avenue. That's the Atrium Senior College Town. 3,000, 1,000, 5,000, 5,000, and UJR jail. 3,000, 1,000, 5,000. 5,000 and UJR jail. Best of luck to you, sir.
14,000. You know, math is not my strong port. I would be a doctor if it was. So that's 14,000.
Yeah, no matter what, we're smarter than doctors. Just got to convince my mom of that.
That's right. It's 14K split, correct?
Okay, I did it. Thank you.
All right, let's see. Make sure. All right, how about William Gear? And sir, you can leave the booth. All right, Mr. Gear. We got 22 CP 213323, position 20, 191 days without indictment, $16,000 good bond as of January the 24th. Aggravated assault, possession of firearm during the commission of certain felonies, theft by shoplifting, terroristic threats. Pre-trial.
Five prior arrests, first offender in 2014, burglary in DeKalb, 2019, burglary. In Kentucky, 2 arrests, FTA 2018, nothing further.
All right, go ahead, Mr. Cho.
Thank you, Your Honor. Good evening. Judge, this is 191 days, I think, as of today.
Yes, sir.
And there was a probable cause hearing held in January. A charge was added at that time. So not the best result for Mr. Gear in the sense that the officer showed up and I think the initial charges were sufficient for the case that we have. We understand the allegations as they're laid out. Notwithstanding that, Judge, no one was actually harmed in this case. And the item in question, which I believe was valued at $46.97, was, I believe, subsequently returned to Home Depot, a mega corporation. Judge, this is a straightforward case. It's very easy. The complaining witness is probably the person that showed up for the probable cause hearing, and there has not been an indictment since then. So for Mr. Gear, it's, I don't think, a very good time for him to just stay in jail for this long time period. Sandy Springs address is a good address, is my understanding. Mr. Gear has a mother who lives in the Georgia area as well with a 404 area code. And Judge, he is a father. He has an 8-year-old son who lives in Georgia, so he has sufficient ties to the community. He was unemployed previously, but was working for construction at Balfour, Balfour, Babutty. I'm not sure how to say that. Babutty company. He was doing that previously for 4 years. Judge, I believe currently bond is at $16,000, Judge. At this point, if I have applaud everything Ms. Bray has said today, and if there is a list and emails have been sent and there's still not been any activity, Judge, at this point, I just don't believe sincerely that there's going to be any priority given to any of these cases. I would ask the court to consider UJR for all these cases, and if there's any complaints or issues, I'll just leave it at that, Judge. Nothing further.
Okay. All right, go ahead, Ms. Patton.
Yes, Your Honor, we would object to a rejection in his bond. He does have a bond as he is entitled to. It is more than fair and reasonable considering, again, the nature of what happened and his previous history. That being said, I believe you are correct. It's a 16 good bond in place, and we would ask that that remain the same. Nothing further from the state.
All right. All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Darius Mitchell, Jason CYNE. Let's see, no drugs, no alcohol, no weapons. You're gonna have a ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. And I'd put down here previously to provide a home address, but you have a home address where you'll be living now, sir?
Judge, the address is the one that's on the intake form. I believe it's his mother's address.
Roswell Road, sir? Is that where you live? Okay, I don't know why, but he must not have thought he could live there before. All right, stay away from all Home Depot stores. Can't go in a Home Depot store at all. Stay away from 2525 Piedmont Road in Atlanta, Georgia, which ends up being what? Midtown? Is that considered Buckhead? I forget what that is. So what we'll do here is 4,000, 100, and 2,000. 4,000, 4,100, and 2,000. Best of luck to you, sir. You can leave the booth. I've already added this one to the list too, Mr. Cho.
Thank you so much, Judge. That concludes my business. May I be excused?
Yes, sir. Have a good evening. Let's see.
Thank
Kareem
you.
Harris.
Thank you, 88 Patton.
Miss Robinson, Miss Pinto put in there, where's 3 South? Is 3 South?
Judge,
not in?
I'm working with Lieutenant Coughlin, trying to get her client in the booth now.
Oh, okay.
Okay.
All right, I see 3 South. Okay, what about Nasir Mead, Mr. Mead? All right, Miss Bray, this position 6, Bostic 22, CP 213165, 197 days without indictment. Nasir, Naseer Mead, $73,000 good bond as of January the 26th. Aggravated assault, false imprisonment, battery, family violence, trafficking of people for sexual servitude, terrorist threats, and act. Pre-trial.
Wait, Your Honor, before we get to pretrial, because I know pretrial is going to mention another case
No,
that
I won't.
ended up.
No, I don't. You know Bostic better than that.
Bostic.
I don't know what you're talking about, 'cause I ain't got nothing that's not supposed to be said.
Oh, I'm gonna fight you, Bostic.
Put them up. I don't have anything that's not supposed to be said.
Okay, well, go ahead and say it. I'll let you say it, but then I gotta talk. Okay.
I got 8 prior arrests, 2 FTAs, a misdemeanor, and armed robbery, 3 counts, criminal attempted felony in DeKalb from 2020.
Did you have another CWAC you're thinking, Ms. Bray?
Your Honor, I just know that this case is connected to a case that I already represented him on, right?
It may have been dropped.
It would.
If it's dropped,
yes.
I'm not gonna say it.
Okay.
Okay, so it's dismissed. There was a hold for this case here, right?
Gotcha.
So he goes to the hold, and then they bring him right back to Fulton County, like within 2-3 days. I want Your Honor to take into account the amount of time that Mr. Mead sat in jail on this other case involving this same person. And he sat months, Your Honor. Trust me, I tried to get him out. And I couldn't.
Do you know that old case number, Miss Bray? So I could put this in my.
Okay, Bostic, you know everything. So you tell her the case number. I think it's 22 CP 210320, but it involves these same people.
And how long was he in on that one?
A long time.
You don't know how many days? I look. Okay.
Well, I gave you.
No, I'm looking. I said I'll look. I thought you knew off the top of your head.
No, I didn't. I should have known. I apologize, Your Honor.
That's all right. I'll pull it up.
My point in bringing it up is that I want Your Honor to understand that, hey, this man been in jail a long, long time. And the first case ended up being dismissed, right? They had a hold from College Park or whoever, but it was connected to the same case, the same people. And so he's just been sitting. We did a prelim on that other case. I just want Your Honor to take into account all the time he's been sitting and nothing has happened. Like the other case, I believe it was dismissed. And then we got this case, but it's the same people, the same set of facts, the same date, all of that. And he's just sitting with no bond. Oh, wait, it says 73. Whatever. 73,000 to me is the same as no bond, because I can't post a $73,000 bond. I don't have money like that.
Okay. All right, Miss Patton. Let's see. I'm pulling up that other case too, Miss Patton. So go ahead.
Your Honor, the state would object to a reduction in bond. He does have a bond, a $73,000 bond that he was given. We would ask that it remains the same. I will honor the court's rules and Ms. Bray's rules to not bring up the other case that is a sensitive matter, but the nature of these charges are very concerning. He also has a pending armed robbery in DeKalb County right now.
Ms. Bray, what you gave me, the case number wrong, is a theft by taking.
But it's connected to this same case.
Okay, I thought it was
because
like
the same victim was alleging that he stole her luggage from a MARTA station. That's how it started way back then. Whatever the incident date the arrest date is. He has been in jail continuously based on that. And then once I took care of that, and they came and got him for College Park, East Point, wherever the hell it was, they just brought him back to Fulton County like within a day or two. So he has never touched freedom on the street, but it's the same thing, Your Honor, and nothing has happened. He has not even, wait a minute, because I don't want to lie. He has not had a prelim on this. Does Your Honor see where he has had a prelim on this?
No, okay, well,
because I don't see it.
Your Honor, I've been guaranteed that they anticipate indictment with this specific case because of the nature of the charges within 90 days. I understand what Ms. Bray is saying. However, I'm going to state again to the court, the nature of these charges are extremely dangerous and concerning. I will not bring them up because I'm trying to honor what the court is saying. Officially, though, as I stated before, the state would object. He does have a bond put in place, and $73,000 good bond is reasonable considering these charges.
right, okay, and I've got a Beaufort, Georgia address, Ms. Bray, is that right, sir? Beaufort? Thumbs up. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 1360 Virginia Avenue and 1471 Elizabeth Lane in East Point. You're going to have a Teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. Don't come here. Don't get gas. Don't get a flat tire. Don't get anything to eat. All right? Throw a snack in your car. Court, see your lawyer only. No further contact with Kira, Kirra Harrington, and Kennedy Jackson. No further contact with Kennedy Jackson. If there's a hold, sir, you'll have 48 hours to have that ankle monitor placed on your ankle. So I got 15,000, 4,000, 4,000, 35,000, and 1,000. Best of luck to you, sir. Miss Travoria, Miss Robinson, could you send an email to
yes, ma'am.
Miss Watts and see if we can get him on a.
I'll send it to Dexter. He's the one who puts them on. I'll just
Okay.
copy.
All right. Yes.
At least let me have a prelim.
Yeah, she'll put him. We'll get him
I'll
on
put it
the
on.
calendar.
Thank
All right,
you.
Best of luck to you, sir.
Your Honor, I think that's the last case I have before you.
I think so. Yep. I think so.
My internet, but it keeps freezing like every 5 minutes. 15, 4, 4, 35, and 1, correct?
Let's see. Just sit down. Hold on.
That doesn't sound right.
Just sit it down. Hold on 1 second. I got 15, 4, 4, 35, and 1.
Thank you.
3,500 or 35,000?
1,000.
1,000.
We'll get you on a prelim and we'll address it once we hear all the testimony. And if it's on mine, Miss Bray, I'll address the bond.
Okay.
Okay. All right. Robbie Mosley. There we go, Mr. Mosley. 22 CP 208405. It's number 7, Boston. 374 days.
Man, Robert Mosley sounded a little bit like Robert Morley. I was like, oh my gosh, Robert Morley's in jail. We need to call somebody quick. Good night, Jonathan. I hope you have a good sleep. You guys are hilarious. I love reading all your stories and hearing all your fun things. Let's continue on. I just want to say, I was thinking this. Oh, the beans are done. They look really yummy. I'm gonna mush up some of them, and then I'm gonna have some. What I was gonna say was, Bostic was saying earlier how she's working hard on what she says and how she doesn't stutter. I'd just like to say you're doing an amazing job, Bostic. You have a lot of information to concisely give to the judge and everybody in a great manner, and you do an amazing job. So, just in case Bostic ever watches, great job. Keep up the good work. You are kicking butt. Of taking numbers.
Not indictment. There is a $75,000 good bond on armed robbery. Free trial.
In 2022, battery on a pregnant person in Anastasia, killings in an FTA in 2022. Nothing further.
All right, go ahead, Ms. Woods.
Hey, Judge, good to see you.
Good to see you.
Mr. Mosley's been in over a year, Judge. $75,000 is essentially no bond status for him. He has been accepted into Georgia Works, and I point that out because he does struggle with stable housing. And so that's why we think that would be a great place for him to go. We did have a preliminary hearing on this case in September of last year. It's still unindicted. I know the charges look very serious on paper. However, I do expect this to resolve completely different. It's a situation at a homeless encampment, Judge. And so I think the state's going to have a hard time finding their witnesses. And I think it's a theft by receiving stolen property at best, but we'll get into that later on. We're just asking for a reasonable reduction. He's 32. He's been here in Georgia the past 5 years. He has his GED. He was working at Wahlburgers, the restaurant. And so his main concern is housing, Judge. And so we're just asking that you'll consider a reasonable reduction so that he can go into his bed at Georgia Works.
All right, I just put this on my list of Miss Wallace. I'm also going to put Mr. Royal on there. Go ahead, Miss Patton.
Ms. Wood, clarification, you said he has been accepted into the program?
Yes, he was accepted actually at the end of December, and I can send the acceptance letter to you in the court if needed.
Okay, I'm take your word for it. Your Honor, the state is amenable to a slight reduction in bond. Again, as stated before, the nature of these charges are rather serious. Also concerned about a likelihood of reoffending based on his history. The state would be amenable to a reduction. I believe it's $75,000 good bond to a reduction to a $50,000 good bond.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Joshua Williams. You're going to have a teletrix monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, and participation in a program. If you get a job, sir, you have to provide the name of your employer, proof of employment schedule, the exact location you're going to be working. Stay away from 3 Farley Street Northwest. $45,000 good bond. Best of luck to you, sir. And I don't see, has there been a prelim on this one? No.
Yes, Judge. I believe September the 14th.
In September. All right. Best of luck to you, sir. You can leave the booth. And I'll put this in my email that I will send here as soon as I finish.
Thank you, Judge. May I be excused?
Yes, ma'am. Good to see you.
Thank
All
you.
right. Now do we have Nicholas Shadrick? I'm trying to find, is it position 28 is the one that's reset, right? Hickmaid and Adanke, that's the one that's reset, right?
Yes, ma'am. Judge,
Yes.
About the Georgia Works program, you want me to put in the information about that? He can participate?
Yeah, please. Thank you so much.
Yeah, I'd just like to have your permission. I'm sorry.
Yes, ma'am. No, Leon Parker. Oh, that's not Leon Parker. Are you Kareem Harris?
Judge, I can unmute the booth to see who he is.
Are you Sahir Duvall? Nope. Oh.
Now, Your Honor, Sahir Duvall, who
No,
used to
okay,
be my client,
hold on. Let's see. What does that say? It says
William Lyle represents him.
Hold on a second, Judge.
Quentin
7 North Booth 1 is unmuted.
All right. Okay, say your name, sir. We took you off mute.
Quentin Shelton.
Quentin Shelton.
Yes, ma'am. That's Your Honor. Your Honor.
No, you're good. I don't see you on my list, sir. Were you told you were supposed to be here today?
Yes, Your Honor.
Let's see. Hold on. Oh, wait a minute. Hold on. Let's see. Quentin Sheldon. Hold on. Here, he must be here. Hold on 1 second. Quentin, how do you spell your first name? Oh, can you unmute him again? Sorry.
Yeah, I'll take him off.
Okay. How you spell Quentin?
Quint. They in the system is O-N, but it's really A-N.
Okay. Well, that may be why. Okay. In the system, then. Oh, wait a minute. Maybe they corrected it. So it's Quentin Sheldon, right?
Yes, Shelton. Yes, ma'am. Yes, Your Honor.
Thank you.
Which case does he think he's here for? The CP case?
Your Honor.
Are you? Do you know which case you think you're here for? Hold on, here it comes.
No, yeah.
Has two cases.
Oh, yeah, okay, hold on. Oh, one's indicted and the other one was just, let's see. Hold on, what in, let's see. I see the CP is loading up.
On the CP case,
Yes.
his last hearing was a prelim in February.
Yeah, let's see. So you have a 37, so you went to court in February?
Yes, Your Honor.
And your lawyer, who is, let me see who your lawyer is.
Eric Cho.
Oh, Mr. Cho, you still on here? Mr. Cho, looks like we need to get him back on a calendar.
Judge, I am. Is he on the calendar today? I didn't see.
No, he's not.
Ms. Shelton, how long have you been in jail?
About 16 months.
So I'll tell you exact number right now. It has been. Well, he's got the SC case, so this is the CP case. So, we have 516 days.
Judge, if you can give me the CP number, please.
22 CP 212871.
Thank you.
Judge, if I remember correctly, one case was indicted, one case was not.
Right.
My Odyssey is not working.
The one I just gave you is the one that's not indicted.
22 CP 212871, right?
Yes, sir.
Judge, we had a prelim, I believe, approximately
February.
Yes, it was reset from January. The officer was a no-show the first time. It was reset again. There has not been any activity in this case. It's fairly straightforward. There was a prelim held.
So you
there's no
did have a
reason why one
prelim?
case.
You finally had the prelim?
That's correct, right, Mr. Shelton?
Yeah, there's a probable cause order on February 17th. Okay.
It's just fairly straightforward. If one case is indicted, the other case I think should be indicted as well. It's a matter of judicial economy and not to waste the bed space in an overcrowded jail. I believe, Mr. Shelton, you don't have a bond on the indicted case, right?
I'm pulling it up. That's in front of Judge Krause.
Yes.
Hold on, let's see.
My Odyssey stopped working, Judge, so I apologize.
That's all right. Okay, hold on. There is a bond order that says 105,000.
Judge, there's a six-figure bond.
Then it's 100. Okay, 80. So now it's 8. It was reduced to 80,000 January 25th.
Well, Judge, 500 days with no income. You can't make income at the jail.
Yeah, I set that at January 25th. It was $80,000. So you'd have to get that back in front of Judge Krause, but we could put this other one on, or put it on for pre-lit. Oh yeah, we could put it back on.
Yeah, Judge, I don't see where a bond motion has been filed. Once he files that bond motion, I'll put it back on.
Yeah, if you file a bond motion in that CP case, Mr. Chair, we'll get it back on.
Absolutely, and absolutely understood. Mr. Robinson will follow your directive, of course. I would just say, Judge, if we are here, I could make an oral motion for bond without Mr. Shelton's objection, ask the court for reduction, and ask that this case be calendared continuously until it gets indicted, would be my suggestion. I will honor and defer to the court, of course.
I don't know where Miss Patton is, or if she's prepared, because I don't know.
I know, Miss Patton, ADA Patton, I don't mean to put you in the hot seat. I know you had I don't mean to put you on the hot
In
seat.
general, I do like to prepare for my motions. However, I appreciate Mr. Cho's, situation that he's in. And if you could provide me with the name of the defendant, if I could just have a second to look, I can even see if that's plausible right now. Because I don't even know this defendant's name. I don't know anything about him to even agree to be able to do an oral argument.
Well, I'll say it like this, no pressure, but the case number is 22 CP 212871. And I'll put it in the chat with the name.
Thank you.
Let's see, and 3 South. Are you Nicholas Shadrick? So we'll get back to you, Mr. Shelton. Nicholas Shadrick. What about Leon Parker? Leon Parker. All right, let's see. This was position 25. Okay, that's all right. That's 23 CP 215617. Leon Antonio Parker got 98 days out indictment, charged with stalking. There's $100,000 cash bond as of January the 21st. Free trial.
Judge, in regards to Mr. Parker, 8 prior arrests, open case 22 SC 181183, aggravated assaulting assigned to Judge Ingram, victim Haley Lattice. 5 misdemeanor, 1 being a DUI, 2 arrests for probation violation, nothing further.
All right, go ahead, Ms. Kennebrew.
Yes, Your Honor, I'm here on behalf of Attorney Rosenhoover for Mr. Parker. As you stated, Mr. Parker has been in custody for 98 days without indictment. Pre-trial did bring up an open SC case that, interestingly, the allegations in that case appear to have happened after this warrant. This case is from 2020, or this warrant was filed in 2020, October 26th of 2020, and it's the same alleged victim. This case is essentially charged as a misdemeanor. We are trying to get an indictment from the state, at least indicted to move with the other case that is moving. We're trying to figure out why this misdemeanor is currently here in Superior Court. Is it going to get indicted when you guys accuse it? A little bit about Mr. Parker. He's 36 years of age. He is a lifelong Georgia resident. He does have family here in Georgia, stepfather as well as stepsisters. He does have an address on file. It is in Fulton County, and it is paid for currently. He did graduate from Osborne High School. He did also attend Gordon Community College for a year. He currently receives SSI. He does suffer from some MH issues. We're asking for the bond to be reduced to no more than $25,000, Your Honor, and for it to not be a cash bond.
All right, so this one looks like I did the TPO, and he allegedly violated the TPO order that I put in place back then. And the incident date on this is somewhere between October 26, 2020 and November the 29th, 2020. Ms. Patton?
Your Honor, we would object to a reduction in bond based upon the fact that, one, our victim is really terrified of this defendant, and I would encourage the court to, as you just mentioned, that they have a TPO against him, and this defendant has already violated that. There's a big concern about him being a danger to the victim, as well as as well as a likelihood to reoffend based upon his previous history. At this time, the state is arguing that he does have a bond set in place, as is his right, and it is more than fair and reasonable considering what is going on in this case.
So I'll tell you that this is a misdemeanor. This is charged as a misdemeanor stalking, and not a felony. Did you notice that, Ms. Patton?
Not until Ms. Kennebrew brought it up. I'm happy to look into it further, but that's the first time that I noticed it was charged as a misdemeanor.
Right, and it doesn't say on the, I don't see anything like bumped up. It just says remains in Superior Court because of the other one. However, I think $100,000 cash is, I don't know a misdemeanor that would get $100,000.
Your Honor, and we're just asking for a reduction. And if the state feels that he is still such a threat to the complaining witness, go ahead and indict the case. That's essentially what we're asking.
You can take a second look at it, because let me see if the TPO is still in place, if it got extended. You need to look at it for a second, Ms. Patton. Let me pull this up real quick. Man, this thing's going slow. This Brady's already broke everybody's computer.
How did I break everybody's computer? You were messing with me. I got it. I didn't. I paid mine.
I don't know when.
So I didn't do it. Your Honor, you're in the case you don't believe me.
Okay. All right, so it was a 2020, let's see. Okay, so that was as of January the 18th, 2022, it was made permanent. My little sloppy signature right there. So January the, yeah. So January the 18th, 2022. So now there's a permanent stalking TPO, but it is still in place. It was in place, but yes, it charged as a misdemeanor. So I'll give you a second, look over it, and then I almost think that'd be unconstitutional for $100,000 cash bond as a misdemeanor.
I'm in agreement with you, Your Honor.
Hey, hold on. Hey, Miss Patton, pull up. No. So I don't know if you have it pulled up, but there's an aggravated stalking. Do you see that? I don't know if you see it or if you did that. He's also charged with an aggravated stalking that's assigned to Judge Ingram.
Yes, Your Honor, I'm here. I'm trying to
And if you see that one had a date of 11/3/2021. It was in judicial hold status, discovery, leave of absence. Let's see. There's a final plea May 2nd on that case. Let me see if that's the same.
That's the case that I referred to that happened. It's I think November 3rd, 2021, and it was indicted. If I'm not mistaken, that's the same case.
I don't see a bond on that one, is there?
No, I believe it's in a no bond status.
All right, Ms. Kennebrew, so 22 SC?
Yes, 22 SC 181183.
Yeah, I think that one is, yeah. There's a judicial hold. Ms. Patton, whenever you're ready.
Your Honor?
Okay,
I was able to take a look at it a little more in depth. That being said, the state is amenable to a reduction. Obviously agreed it is unconstitutional to have a $100,000 bond on a misdemeanor charge.
Yes. And for the record, Judge Manning did not set that.
Nope, you didn't. You did not set that. So we're amenable to a reduction, but we would just like to keep the court's attention to the fact that this is a case where the victim is still very much in concern for her safety.
And I do think that the 22 SC 181183 is in no bond status. That's a felony stalking, aggravated stalking assigned to Judge Ingram.
Correct.
All right, so no drugs unless prescribed, no alcohol, no weapons, no further contact with Haley Landis, Landis. You're going to have a teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. As long as you supply the name of employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working. Stay away from 424 Decatur Street Southeast. Sir, are you going to be living in Fulton County? Thumbs up or thumbs down? All right. So, and Ms. Pat, I think I told you before that Teletrix has an app for the alleged victims, if they're victims in some cases, that they can download, and it will not tell them where he is, but it'll say if he would be within a mile of her location. Let's see. So you're already in no bond status, sir, in the other case. So I think statutory, but I can do the $15,000 good bond. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Kennebrew. All right, now we should have Nicholas Shadrick.
Concludes my business. May I be excused?
Yes, ma'am. Thank you. Nicholas Shadrick. Are you Nicholas Shadrick? No Nicholas Shadrick yet. Do we know where Nicholas is? Wait, he wasn't, is he the one in Forsyth, right? So you got to waive his presence, right, Mr. Rose? Is that true?
Nicholas Shadrack should be coming in booth.
Okay, who is the one they're gonna waive his presence?
That's gonna be Sahir Duvall, and he's represented by Attorney William Lyle.
Oh, okay. Oh, yeah. All right, Nicholas Shadrack. Nope. All right, let me get the info. All right, so here Duvall. You know he's not gonna be here. All right, that's 21 CP 203374, 212 days without indictment. Aggravated assault, possession of firearm or knife during the commission of or attempt to commit certain felonies. There's $150,000 good bond as of January the 18th. Rah!
Duval, 24 prior arrests, 5 arrests for probation violation, 1 FTA, 2 misdemeanors, 4 felonies. Prior ag assault firearm during ag assault 2011, open case 23 CP 215-840, ag assault riot in a penal institution. 22 SC 183396, cruelty in the second, firearm by, firearm during, reckless conduct, Judge Eden. Nothing further.
All right. Go ahead, Mr. Lyle.
Yes, Mr. Duvall is age 25. He's been in Atlanta his entire life. He has 7 children, and he's working his GED because he only got to the 10th grade. He will be living in Atlanta, Georgia, so within Fulton County. Given that he's been in prison or jail for 190 days at this point, we would request that his bond is reduced to $120,000 because he's going to be in the jail for a little while anyway because of the other open cases. Looks like he had a preliminary hearing on January 18th.
All right, Ms. Patton.
Your Honor, just to clarify, we're on position number 1. I didn't hear you.
Yes, ma'am. Yeah,
Yes.
Sahir Duvall.
Okay, the state will consent to that. That's reasonable in this case.
All right, what was that amount again, Mr. Law?
120.
All right, so 100 on count 1, 20,000 on count 2. No drugs unless prescribed, no alcohol, no weapons, no further contact with TREVEALE, last name Oliver. Teletrix, monitor, paid for by the Orca Project with a 24-hour curfew, court, lawyer, medical, employment, as long as he supplies name of employer, proof of employment schedule, the exact location he'll be working. Stay away from 523 Cleveland Avenue. And before it said must reside at 2512 Campbellton Road, is he still going to be able to do that?
I believe so, yes.
Okay, must reside at 2512 Campbellton Road. 100,000 and 20,000. Thank you, Mr. Law. Mr. Law, maybe you want to pass it on. Not sure what we're going to do about folks being up in Forsyth when they can't get there and they don't have. So I guess if people have clients up in Forsyth, Ms. Robinson and I were talking about it, you may need to talk to them ahead of time and see if you can waive their presence. I don't know. I don't think they have the Zoom capabilities. I don't know what we're going to do.
From what I understand, they don't. Apparently, they can take Zoom calls from lawyers up there through the security system, though I went in person this time. But yeah, it sounds like they're not going to be able to do any of these Zoom calls for that, the hearing.
And I don't know if they're going to have the body power to like send somebody, that's, so I don't know. But anyway, keep in mind, anytime they're at, Cobb or somewhere else, y'all may want to get permission to waive just in case.
Right.
I would, but anyway, all right. Thank you so much. I appreciate it.
It may be excused.
Yes, sir. Are you Kareem Harris? All right. Ms. Pinto. Position 2223, CP 215-584, 99 days without indictment. No bond as of January the 20th. We got Kareem Harris, aggravated assault, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, terroristic threats and acts. Preach, raw.
Kareem Harris.
Kareem Harris, position 22.
There he is. Kareem Harris. This is his only prior arrest in Georgia. He had 2 prior arrests in Pennsylvania. I don't think he has any convictions. Nothing further.
All right. Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Harris is 30 years old. He's a high school graduate. If released, he would reside with his mother in Wilmington, Delaware, Judge. All of his family are in Pennsylvania or Delaware. So we do ask that he be allowed to reside with them. Otherwise, he would have to live in a shelter here in Atlanta. He has been in Atlanta for the past 3 years. He was working as an independent contractor doing construction for 3 years. And he also has a nutrition shake business. Had been doing that for 1 year at the time of his arrest. He was living in a rooming house. He resided there for 2 years. And that is the incident location, Judge. So once again, with his family out of state, we're asking that he be allowed to reside there in Delaware with his mother. As stated, he only has 2 prior arrests. He has no convictions, felony or otherwise. So there's no reason to think he would commit a felony if released on bond. He's of no risk to intimidate any witnesses, especially if he's allowed to reside in Delaware. His family is low income, Judge. We are asking for a bond. Of course, he is entitled to one. He's been incarcerated 99 days with no bond and no indictment. We would ask for $5,000 on each charge, so a total of $15,000.
All right. Ms. Patton?
Yes, Your Honor. As stated, Mr. Harris is entitled to a bond. The state at this time is asking for the aggravated assault charge to be a $10,000 good bond, possession of firearm or knife during commission, a $10,000 good bond, and the terroristic threats and acts, a $1,000 good bond. This is based upon the fact that there might be a pose of a threat to the victim, in this case, Mr. Vincent Williams. However, if Your Honor is inclined to and state a lower bond amount, we would ask that the ankle monitor be put in place, and the state has no objection to Mr. Harris living in Delaware, I believe, with his mother and father. Is that correct?
Delaware, yes. Mother. I'm not sure about father.
My apologies. In Delaware with his mother. Nothing further from the state.
All right.
All I would add, Judge, I don't think the ankle monitor company can monitor him outside the state.
Oh, they can.
They can? Okay.
Yeah. No drugs unless prescribed, no alcohol, no weapons. Stay away from 412 Corvair Drive, Corvair Drive Southeast. No further contact with Vincent Williams. You can have ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, or employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You have to supply that to the ankle monitoring company and to Ms. Pinto. Stay out of Fulton County unless you're here for court or to see your lawyer. Matter of fact, stay out of Georgia unless you're here for court or to see your lawyer. You can't even come to Georgia for a pecan log. All right, sir. You fly straight into the Atlanta airport, you go straight to court, and you leave. Don't stop for anything else. 10,000, 10,000, and 1,000. All right, make sure you update your address, sir. Best of luck to you. You can leave the booth. So, Nicholas Shadrack. Thank you, Ms. Pinto.
Thank you, Judge.
I'm trying to get an update from the jail on him. He should be in 7 North. I'm calling Lieutenant Coughlin to see if we can get an update real quick.
All right, but we can go ahead and take Ms. Pinto's other client, and I'm going to destroy his name, Ms. Pinto, if you want to help me.
It's Mbake, Judge.
Mbake. Kadim Mbake. It's the add-on for bond modification. 22, Mr. Mbake, you got to turn your camera on. 22, CP 213693. Let's see, he's out on $170,000 bond for armed robbery and 1 unlawful person be employed by associated with criminal street gang to participate in criminal street gang activity. Unlawful for a person to commit the offense with the intent to earn, obtain, maintain, or increase status. And unlawful for a person to acquire, maintain through criminal gang activity proceeds derived from such, and possession of firearm during the attempt or the commission or attempt to commit a felony. Bostic, try. Anything I need to know?
No.
All right, go ahead, Ms. Pinto. What are we doing?
Thank you, Judge. This is a very simple request. Mr. Mbake is on an ankle monitor and a 24-hour curfew. However, he was not granted exceptions for work, job interviews, or court. We're asking that those exceptions be added. He needs to be able to work to help support himself and pay his bills like anyone else. So we just ask for those very simple exceptions.
Did I really not put that in? Is that mine? I didn't put that in there.
It was a different judge.
Oh, okay. All right. Ms. Patton?
No objection from the state.
All right. So that ankle monitor paid for. How's the ankle monitor holding up, sir? Is it Okay, all right, because I could switch it to the Teletrix if you wanted. I think they're a little less capable of getting like the charger plug messed up because you plug the actual charger, Miss Pinto, and then you connect the little charger to the watt. So you don't have to sit there like connected to the wall. Let me switch it out.
Would you prefer that, Mr. Mbake?
Because it kind of looks like one of the big smartwatches.
Yeah, you can turn your mic on. Is that better for you?
Yes, ma'am.
Okay,
Okay,
'cause
should
you
we
don't have
switch
sit
it to that, Judge?
Okay, yeah, so it's a Teletrix. And what's the monitor paid for by the work project? Ms. Young, what's that wording that needs to be Teletrix?
I can send it to Miss Pinto, but the wording is Teletrix monitoring will be paid for by Fulton County through AA. All county monitoring, all previous imposed conditions remain in place. But I can send it to Miss Pinto.
Yeah, she can send it to you, Miss Pinto. So that may work a little bit better for you. So we can do that. And that'll include like job interviews. But sir, the main thing is you gotta let them know when you're going and things like that, okay? And you gotta let Miss Pinto know. But you'll be able to go and switch that out.
Right. So does he go to A&A All County to switch that out?
So they do the ankle and the Teletrix. I think what he'll do is, see, these people need to like meet with y'all instead of me. With the order, the stuff will get turned over to them and then they'll set up the time to switch it out. Until then, though, sir, do that with your ankle monitor too. Let me see where this Teletrix people are. Don't they get in touch with them, LT? Let's see.
Excuse me, Judge.
When they're gonna do the Teletrix, they'll get a copy of this order, right?
I'm not certain, ma'am, but I'll find out.
Yeah, I think it's the, let me see.
He's not in custody, Your Honor.
Oh yeah, but I mean they should get a copy of the order. So let me see. If you let me look up their website because you can just call them, Miss Pinto, or he can call them. Hold on, and tell them because he'll have a copy of the order. TRX. So it's TALITRIX. So you ready, Mr. Mbake, to write the number down?
Yes, ma'am.
All right, it's 678-799-7677. All right, I'm sure Miss Pinto or something will reach out, but they should be able to tell you where to go. I think their office in Alpharetta, go by there and they'll switch them out. Okay, all right, he gave me a thumbs up. All right, best of luck to you, sir. Miss Pinto, you can just shoot me that.
Great, thank you, Judge.
Okay.
Judge, Lieutenant Coughlin has informed that Mr. Shadrack Nichols is in medical. I'm not sure if the attorney representing him wants to waive his presence, or if he wants me to try to have him reset.
Could we please, sorry, yeah, I would need to speak with my clients about waiving, so yeah, could we please have him reset?
I'll reset him, no problem.
Thank you.
All right, thank you. Anything else?
Did Mr. Shelton leave?
I think he did. I saw him leave. Also, real quickie, Mr. Cho, and we'll get him on. Is that he just has that one other case?
The one indicted. I know Miss Robinson will do an excellent job. So
Yeah, we'll
been a long day.
I know, right? We'll get him on there and take care of it. So it was just that one case, though, right?
That's my understanding. Yes, Your
Okay.
Honor.
Yeah, we'll get him back on there. Thank you, Mr. Cho. Is that it for everybody? That can stop the stream?
I think Mr. Rhodes wins. He waited all day and then
Mr. Rhodes and I actually used to go against each other in DeKalb County. So we're very familiar with each other.
Judge,
This
I
is
have
my
one
courtroom then.
question. Should I add language explaining that
Yeah, switch out the ankle monitor for the Teletrix if you just do
right?
that.
Okay.
Yeah. If they're ordered
Thank
to
you.
change it from the ankle monitor to that. I think they're a little more sturdy. They seem to be. I mean, I looked at them and they seem
Good night, everyone.
Well, guys, I thought that was a great Manning episode, as usual. I was out on the porch. We were talking about stalkers in the chat. Let me see if I can find this picture because it wasn't like it was like an art picture. Give me 1 second and let me see. I can't, but I'm probably looking for the wrong thing. That's okay. Anyways, guys, I have a lot of learning to do tonight. I'm gonna try and figure out how to put the memberships on the page as soon as I can. I also have to clean up. But I do. The good news is that we had a lovely stream. I had a really nice evening with you guys, and I I hope that all of you aren't. I'm so glad that it doesn't cost money for points, and none of you are totally bankrupt this week because you got addicted to gambling points on YouTube. Anyways, I love you all. I want you all to have a wonderful evening. Oh, look, I can have face tattoos. Face tattoos. Okay. Seriously, forehead tattoos. It's late. Okay, we gotta go. I love you all very much. I thank you so much. I want to get a list of this video. Oh, last thing. I posted a video earlier today, my first monetized video that I posted. And it's like almost got 1,000 views already. So that's exciting. Okay. Thank you guys so much. I love you all. KCC stamp. For I love you all so much. I will talk to you soon. Thank you again. Why don't you go leave a comment on this video with your favorite TV show that you think everybody should watch? Because that was a really fun conversation tonight. Okay, guys, I'll talk to you later. Bye.